Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. This is Judge King with Judge Floyd and Judge Clee, and we're pleased to have you here in this interesting case. And I want to say that Judge Floyd and I are honored to sit with our colleague from Northern West Virginia, Judge Clee, during the course of these proceedings. Our first case is number 19-1609, Adams versus American Optical Corporation et al. Counsel, Mr. Martin?
Yes, Your Honor.
We're pleased to hear from you.
Thank you, Your Honor. My name is Mike Martin, and I represent the family of Gary Adams in this appeal, and I thank Your Honors for the opportunity to be here today. The question presented before the court today is when the statute of limitations ran in Mr. Adams's case, a man who suffers from co-workers pneumoconiosis. The plaintiffs submit, Your Honors, that the trial court erred in failing to consider evidence that Mr. Adams's early symptoms were attributed to non-occupational causes and non-occupational diagnoses. Standard of review in this case requires the court to review the case but prohibits the court from weighing the evidence or reaching factual inferences contrary to the non-movement's competent evidence. What happened here is that...
Martin, this is Judge Floyd. Do you dispute that Mr. Adams had suffered an occupational injury from the inhalation of coal dust prior to September 29, 2016?
Yes, we dispute that, Your Honor, because he had...
Based on what evidence?
If you look at the evidence, first of all, of Dr. Alam and his conclusion beginning in 2007, which can be found on court transcript 955 through 57 and 957 and 1162, those excerpts illustrate that in 2007, Mr. Adams was actually diagnosed with something called granulomatous disease or histoplasmosis. That is a non-occupational disease. In fact, his CT scan from 2007 was negative for any kind of occupational lung disease. So if we're looking at 2007, we know at that point in time, Mr. Adams is being told by his pulmonary doctor that he does not have co-workers pneumoconiosis. And that's exactly what Dr. Alam told him, as reflected in the record. In 2009, after Mr. Adams received another letter from NIOSH, there's a screening program in place where co-workers are screened through a program under NIOSH requiring co-workers to be screened for x-rays. And he received another x-ray in 2009 suggesting that he might have co-workers pneumoconiosis. He goes back to the doctor, and in 2009, he goes back again to a pulmonologist, Dr. Alam, who tells him again that he does not have co-workers pneumoconiosis, says he's perfectly fine, and that's on appeal record 960 to 961. A CT
So what was the date
scan
of that?
That's 2009. That would have been August 24th of 2009. There's a CT scan study, the CT scan study on August 24th, 2009, which can be found at the record at page 1164, actually says he's negative for co-workers pneumoconiosis. Again, because he suffers from a granulomatous illness, which may look like pneumoconiosis by chest x-ray, but is not an occupational illness. And that's a key point here that's identified in the Mine Safety Health Administration regulations. And that is that these x-rays that are taken through these screening programs, and this is in reference to the provision in the CFR, 42 CFR 37.2. In these screening programs that are conducted, chest x-rays under the standard are not what we call pathognomonic. I knew I was going to have a problem with that word. Dust exposure. Because on scarring and looking at chest x-rays, scarring can mimic many diseases. Coworkers pneumoconiosis looks like histoplasmosis. It looks like granulomatous disease. It can look like a variety of fungal illnesses. And so an x-ray standing alone does not establish a diagnosis. And this is undisputed by the experts. Both the defendants and the plaintiff's expert agreed to this. And the statute directs that. So the fact that Mr. Adams got letters from NIOSH saying you've got coworkers pneumoconiosis doesn't mean he's got it. What the statute requires, or what the regulations require, is that it has to be clinically correlated. So he does the right thing. He goes to the doctor. And so the court's conclusion on page 1685 of its opinion that Mr. Adams had coworkers pneumoconiosis in 2007 or 2009, that's exactly what the court says on that page, is actually contradicted squarely by the evidence where the doctors were in fact telling him he didn't have it. And had he filed,
when do you say, Judge King, when do you acknowledge that he had coal miners pneumoconiosis?
October 2nd, 2014, which is when he was diagnosed with rapidly progressive pneumoconiosis. On that day, what was discovered for the first time was massive conglomeration on Mr. Adams's lungs. This massive yes. And this massive conglomeration had not been seen before. What had been seen before were things that mimicked other illnesses, and in fact, because it mimicked other illnesses, Mr. Adams had been told he didn't have pneumoconiosis. Had he filed a lawsuit at the time, he would have been granted summary judgment against him because he couldn't meet his burden of proof. The other conclusion that the court weighed
October 7th, 2014 brings you within the 2 years. Is that what you?
Correct.
What you say? And
that's correct.
But you have a problem with this Virginia law. Doesn't have a discovery rule.
Well, I agree with that, Your Honor. What Virginia law keys off of is when the injury occurs. And so we look to Locke versus John Mansfield, which is kind of the key case that controls here. It's a 1981 Supreme Court case from the state of Virginia. And what Locke says is that in order to determine the time that the plaintiff was hurt, and I'm reading from page 905 of the opinion, it must be established from competent evidence produced by a plaintiff or defendant that pinpoints the precise date of injury with a reasonable degree of medical certainty. Prior to October of 2014, there is no statement by any doctor to a reasonable degree of medical certainty that Mr. Adams has pneumoconiosis. In fact,
Mr. Martin, let me ask you that question about you used the word pinpoint. Does your argument depend on this court holding that the pinpointing of the date of injury cannot happen retrospectively under Virginia law?
Yes, because, Your Honor, if you look at it retrospectively, the problem with doing that is that because the diagnostic information that is used when doing a retrospective analysis is based on information that has not yet occurred.
Well, how would that rule differ from the sort of discovery rule Virginia has rejected?
It is differing in this way. What has to exist in order to establish injury is some conclusion based on reasonable medical certainty that the illness exists. And so Well, you can do a retrospective analysis of any illness, including pneumoconiosis, and say, well, you know, now that I've got all these facts, now that I see the conglomeration and these new events occurring in later years, I now know that what probably happened is that he got pneumoconiosis back in 2007 or maybe even as early as 2000. You can do that exercise, but that exercise is based on events that occur later. For example, based upon the presence of massive conglomeration, which then results in the confirmation of the injury and the actual diagnosis based on reasonable certainty. What you have before that date, Your Honor, is nothing based on reasonable certainty, but a constellation of symptoms which suggest illness, no doubt, but not necessarily occupational illness. For example, the court concluded on page 1685 of its opinion that Mr. Adams's moderate restrictive defect, his shortness of breath, which occurred in August of 2013, was caused by exposure to coal dust. That opinion did not exist in 2013. That opinion occurs much later, 2016 to 2019, once he's diagnosed with pneumoconiosis. In 2013, Mr. Adams had a diagnosis at that time of essential hypertension. That was a firm diagnosis, and essential hypertension also causes shortness of breath. He also had the running diagnosis of histoplasmosis and or granulomatous disease, which can also cause shortness of breath. It was also suspected that he had pneumonia at the time, which can also cause shortness of breath. These were all non-occupational causes that were diagnosed based on reasonable medical certainty. And the court erred by failing to consider those non-occupational causes and applied what the court just suggested, a retrospective analysis, which can't be done. And the reason a retrospective analysis can't be done is because plaintiffs, of course, don't have the crystal ball and aren't able to make that looking backward analysis until they get the actual diagnosis. At the time, these parts of these information, these diagnostic aspects, were a product of other diseases. Finally, in looking at the chest x-rays, which, as I said earlier, are not diagnostic and, in fact, as a matter of federal regulation, are not pathognomonic of dust exposure, we see in 2007 a negative CT scan for coworker pneumoconiosis, establishing that there was granulomatous disease. We see in 2009 a negative CT scan. That's the actual word used in the CT scan report. We see in 2011 another non-diagnostic report that states that the X-ray is consistent with granuloma. We see in 2012, and this is an X-ray discussed by the lower court, an X-ray by Dr. Buck, and Dr. Buck uses the word micronodular interstitial process consistent with coworkers' pneumoconiosis, but again, not clinically correlated. And at that time, micronodular interstitial process can be granulomatous disease just as easy as it can be silicosis, or it can be any other type of disease. It is not diagnostic without clinical correlation. And we know that by this point in time, Mr. Adams had gone to the doctor on multiple occasions and received a clinically correlated diagnosis of a non-occupational lung disease called granulomatous disease. And he could not be expected to have filed a lawsuit during these years. Later, in 2015, we see a March 19th chest X-ray that reads patchy mid-lung opacities consistent with pneumonia, granulomatous or non-granulomatous infection. Again, even in 2015, the chest X-ray was suggesting non-occupational causes. The court should have considered all of these pieces of evidence in realizing that there is a genuine issue of material fact with regard to when the injury occurred and when Mr. Adams would have been diagnosed with that injury.
Now, hold on a second. If you're right on that, if you're correct on that, then how would that fact be resolved?
That fact is resolved when the plaintiff presents evidence, or the defendant, based on reasonable medical certainty that a diagnosis of pneumoconiosis exists. That is when the injury occurs.
You're saying that the question of the applicability of the 2-year statute of limitations should be submitted to a jury?
Yes, because it's a mixed question of law and fact under Virginia law, and that's Gordon versus Heritage Fellowship, Virginia Supreme Court 2017, which on page 271 holds that a statute of limitations presents a mixed question of law and fact. Here, the evidence that we presented establishes no diagnosis of coworkers' pneumoconiosis of any type until 2014 in October. Prior to that time, while there may have been, I believe that's my time. Yes, I think my bell rang, Your Honor.
You can finish your sentence there if you like.
Well, while there may have been many symptoms suggestive of lung injury, they were all diagnosed as non-occupational related diseases. Therefore, an injury had not occurred because no diagnosis had been made.
Very good. Thank you. And you saved a bit of time for rebuttals, I understand.
Yes, Your Honor.
Okay, thank you. Now, we're going to call on the other side. Is that Mr. Spurlock or Ms. Brown?
Your Honor, it's Trent Spurlock for Mine Safety Appliances Company.
And Your Honor, Carol Browning for American Optical, and we have agreed to split the time with Mr. Spurlock having 12 minutes and with me having 8 minutes.
Very good. Good to have you all here. Look forward to hearing from you. Go ahead, Mr. Spurlock.
Thank you, Your Honor. Again, Trent Spurlock for Mine Safety Appliances Company. I want to make clear to the court the only thing that's material to the court's decision here is, did Mr. Adams, based on reasonable medical probability, begin to develop occupational lung disease before September 29, 2014? And I want to briefly point out 3 important facts. Mr. Adams admits he was diagnosed with an advanced form of occupational lung disease, coworkers pneumoconiosis, on October 2nd, 2014. It is undisputed that CWP, or coworkers pneumoconiosis, take at least 5 years to develop, and Mr. Adams' counsel acknowledged before the trial court, as he must, that the onset of that advanced form of disease began before September 29, 2014. And I think the court's inquiry could stop right there. In the cases cited by all the parties, the Joyce case, for example, the Large versus Bucyrus-Erie case, those simple facts were enough to establish that the cause of action had accrued more than 2 years before suit was filed. But in this case, if the court wants to go further, we have offered the trial court and this court a complete medical record, which did not exist in many of the other cases. We've given the court 20 to 25 different documents covering 3 to 16 years before suit was ever filed that show the onset and progression of coworkers' pneumoconiosis and occupational lung disease. If the court has not done so, I would suggest that it merely read the depositions of Dr. Alam and Dr. Lockey, which can be found in the record at 934 through 1333 and 836 through 933. And I think that will resolve any of the disputes about the records, and the court will see how many times the doctors over and over and over from 2000 through 2014 link the findings to occupational lung disease.
Mr. Spurlock, Mr. Spurlock, this is Judge Cleaves. One quick question on that. Does Virginia law permit that retrospective review of the symptoms at the time?
It does, and I'm glad you asked that, Your Honor. It absolutely does. If we look at the case law that both parties agree to, the Locke case says that the time of injury will be established from available competent evidence produced by a plaintiff or defendant, assuming, therefore, that once the lawsuit begins, there will be determination through expert proof that looks back at the records to determine when there was an onset of disease. I will also point out that the Lockport says, and many other cases that we've cited stand for the proposition that when the onset of disease may be established before any symptoms, before any impairment, and even in those circumstances, expert medical testimony will demonstrate that the injury occurred weeks, months, or even years before the onset of symptoms. That necessarily assumes that there is a retrospective review of the record to determine when disease onset. And I would suggest that in the Joyce case and the Large case, which the parties have cited, that is exactly what was done. In the Joyce case, for example, you had a X-ray in 1970 that showed pleural thickening, and the court acknowledged that not until 1981 was pleural thickening linked specifically to asbestos-related diseases, and the lawsuit was filed in 1983. But the court found, based upon a retrospective review, looking back at the medical evidence, that as of 1970, the cause of action accrued and the statute of limitations began to run. So, you know, the other thing that the records in this case show is that this is not an inequitable result. And I know that's ultimately not part of the court's decision, but we think it's important to note that between 2000 and 2009, Mr. Adams was receiving multiple letters from NIOSH telling him he had coworkers' pneumoconiosis and to get to a lower dust profession. He was being told by his doctors in 2007 and 2009 to get out of the mines, but he chose to keep working. By 2009, Mr. Adams specifically testified he knew he had black lung disease and he had become a Part 90 minor. As of 2012, Mr. Adams was signing and completing medical histories for doctors, noting himself and signing it that he had black lung disease. And in 2014, outside the 2-year limitations period, he filed a federal black lung claim against his employer because he had black lung disease. So the fairness of the statute and the lack of the discovery rule in Virginia, like I said, are not ultimately relevant to this court's decision, but we feel that the lengthy medical history in this case and Mr. Adams' awareness of his alleged injury for so long make this an easy case to affirm. And we already talked about the standard for reviewing the medical records and the appropriate standard. We believe that there's no question.
This is Judge King. He says it was like a catch-22. I mean, he didn't use that term. But if he'd filed earlier, you would have thrown him out because he didn't have any medical evidence. So he filed after his October of 1974 diagnosis with Dr. Rasmussen, and it gets thrown out because of the Virginia no discovery rule. So he's in a box. So under your theory of the thing, he can never make a claim. You say it takes 5 years. That never would come within the 2 years.
Yeah, Your Honor, and thank you for that question.
Never had this kind of claim by a Virginia coal miner or a West Virginia coal miner or a Kentucky coal miner. The coal miners are treated differently than the asbestos plaintiffs. They made a special rule for the asbestos plaintiffs down in Virginia, as Judge Jones talked about.
That's right, Your Honor, and they specifically have not done so and chose not to do so for coworkers' pneumoconiosis or any similar disease. When they changed the statute, the accrual statute in 1985, I believe it was, for asbestos, and then most recently, this year, they made another change to the asbestos statute, the statute relating to asbestos, making it a two injury state, making Virginia a 2-injury state. And on both those occasions, the General Assembly of Virginia had the opportunity to make a change to the law for a broader spectrum of diseases, but specifically did not. So we are back to what is applicable to this case is the accrual for personal injury causes of action, which is 2 years from the date of injury. And going back to Your Honor's initial question, or what I believe it to be, it is, I would say that Virginia law specifically states that the difficulty in ascertaining the existence of a cause of action is irrelevant. And when the injury or damage is unknown or difficult or even incapable of discovery, does not matter under Virginia law. But again, I would submit to the court, and I'd like an opportunity to briefly review the records, some of which Mr. Martin went through, that I believe there were multiple opportunities to have filed a lawsuit, just as he filed a claim for black lung. I think that's an important thing to remember. You know, Mr. Adams in 2009 was taking advantage of becoming a Part 90 minor. In 2012, he was telling doctors, he was signing forms that said, I have black lung disease, that's part of my medical history. And in 2014, outside the statute of limitations, he's making a claim for federal black lung disease. There's certainly no reason he couldn't have done the same thing and filed a lawsuit outside or within the statute of limitations period, but he's not.
Mr. Spurlock, I guess your argument is that it's just common sense that that disease did not develop on September 28th and was discovered on October 2nd. I mean, I guess that's the argument you're making, that you would not have gotten this disease in a matter of a few days.
Yes, we're absolutely making that argument, as well as several others. I think the court can absolutely rely upon that idea, and as the trial court noted, that is supported by the record. The admission of Mr. Martin at the trial court level that, yes, the disease, of course, started before, long before September 29, 2014, was based upon the medical evidence. You can't have an advanced form of CWP that develops in the course of 3 days. And the court also cited to the undisputed evidence provided by Dr. Alam that co-workers' pneumoconiosis typically takes 10 to 15 years to develop. But at the very least, even in an accelerated form of the disease, it takes at least 5. And that is undisputed, and I think that...
Under that evidence, the pneumoconiosis, co-workers' pneumoconiosis case could never be the subject of a lawsuit like this. Could never be. In Virginia, under Virginia law.
No, you could, I think it certainly could be. You could, Mr. Adams, for example, could have filed a lawsuit when he received 3 different sets of letters from NIOSH, and at any of those times between 2000 and 2009. And I would submit that the court...
But then, as your adversary there says, it had been thrown out summarily because he didn't have any medical evidence. Under Virginia law, you've got to have medical evidence.
If the court... Sure, and I think that evidence...
That's the reason I use the term catch-22. At least I remember that back when I was in school. From World War II, they called it catch-22. You're screwed over whichever way you look.
Absolutely, Your Honor, and I think I'm about to run out of my time. May I have a moment to answer the question and conclude?
Go right ahead.
Okay. Your Honor, again, I would say that, well, first and foremost, that Virginia law does not provide for the discovery. There is no discovery rule, and it does not matter if it's difficult or incapable of discovering outside of the limitations period. But I would ask the court to review the records, to review the testimony. Between 2000 and 2009, you have letters and x-rays over and over and over that Dr. Alam says this is evidence within a reasonable degree of medical probability of simple cold coal workers pneumoconiosis, stage 1 coal workers pneumoconiosis. But then if the court wants to completely discount 2000 to 2009, and because of the CT scans, and focus only on the time period between 2009 and 2014, that's fine too. In fact, we know that coal workers pneumoconiosis starts about at least 5 years earlier and takes at least 5 years to develop. So 2009 is a fine starting point should the court choose to focus on that time period, because what we have in that time period is a progression of the disease, a progression of impairments. We have x-rays in 2012 by Dr. Buck, which show interstitial nodularity, which is, Dr. Alam says, is a specific finding linked to coal workers pneumoconiosis, and there's no disputing that fact. It's not, Dr. Alam does not say that was a finding that could be linked to granulomatous disease. But we've offered the court multiple records about which
I think the bell went off, and your colleague there has some time, unless you want to take some of her time.
No, I don't, Your Honor. I will stop, and I would just say that there's a lot of records to choose from, and we believe that any one of those the court can reach the conclusion and affirm the trial court's decision. Thank you very much.
Thank you. Ms. Browning?
Yes, thank you, Your Honor. Your Honor, I want to start by pointing the court to the statute that's at issue here, one of the two. It's Virginia Code 801-230, and it says, a cause of action accrues on the date the injury is sustained and not when the resulting damage is discovered. And Mr. Adams really argues clearly for a discovery rule. And the courts have told us again and again and again that Virginia law does not recognize a discovery rule.
I took it that he was arguing that he needs a jury trial to decide whether this 2-year statute of limitations is applicable. Is that wrong?
Well, no, he did say that to the court, Your Honor, and I think it's because he is saying.
Can you get a jury trial to decide this issue in under Virginia law?
No, Your Honor. In this factual.
You say you can't, but I think that under the precedent of the Virginia Supreme Court, you can submit the statute of limitations applicability to the jury.
In the right case.
The factual aspect of it. You can as appropriately submit to the jury. Indeed, it was the case, a unanimous decision by the Virginia Supreme Court in August of 2019, which was after 2 or 3 months after this decision was rendered by Judge Jones, where they specifically affirmed that principle of law.
Your Honor, I agree that if there are substantial issues of material fact regarding the statute of limitations, then it would be appropriate to submit it to the jury. In this case, there are no substantial issues of material fact regarding the fact that this injury clearly occurred outside of the limitations period. And that's
exactly. So the factual question is where you and Mr. Martin differ. He says there are disputed issues of material fact on that.
Well, Your Honor,
Mr. Spurlock say there are none. Yes.
Yes. I mean, and I think it depends upon the way you look at it. If you look at it in the retrospective analysis, that is clearly permissible and appropriate under Virginia law. And looking at this, I mean, that's the way that the statute of limitations is decided, and there are a number of cases that discuss that point, including a Fourth Circuit case, the Smith versus Danick case. And in that case, it dealt with a pedicle screw that was implanted in the plaintiff's spine. And the plaintiff claimed, and a few years after it was implanted, there was a pedicle screw broke, and the plaintiff filed suit. And the Fourth Circuit said you're too late, that the court said that it's too late, that I'm sorry, Your Honor, that the cause of action accrued when the screw was implanted, even though the plaintiff had no injury at that time and had no reason to suspect that anything was wrong. That is the law in Virginia. And in this case, Dr. Alam's testimony, looking at this in retrospect, which he's permitted to do, he was asked, do you believe as of 2007 or 2009, Mr. Adams had some degree of CWP scarring in his lungs? He responded, yes, it's possible and probable. He said that COPD, emphysema, and bronchitis linked to occupational lung disease were present in 2007, 2008, and 2009. He was asked, do you believe at this time he, Mr. Adams, had some degree of CWP scarring in his lungs as of the last time you saw him in 2009? And Dr. Alam's answer is, that is likely possible and probable. And that is the testimony from Mr. Adams' own expert. So there is no evidence in this case that, judging back in 2007, 2009, or later on at any point, that the court, that Mr. Adams, the evidence is that he had poll workers' pneumoconiosis, looking at it in retrospect.
Ms. Browning, this is Judge Clee. Following up on Judge King's question, I think now we all recognize that in Virginia, a question of fact with respect to the application of statute of limitations could be a jury question. You seem to advocate that this case doesn't require that length. Where do we draw the line? How do we draw the line between when a question has to go to a jury and when, as in this case, a district court can make a determination of fact and law?
If there are questions of material fact, and here the trial court properly reviewed the facts, considered the undisputed facts, and where the facts were disputed, looked at them in the light most favorable to Mr. Adams, which is the appropriate standard for the district court to follow.
And you base that on the testimony of Dr. Alam and Dr. Locke?
Yes, and on the court's opinion, where the court goes through and explains how he performed his analysis. So, I mean, if clearly questions of summary judgment are appropriate decisions by the court, otherwise you wouldn't have summary judgment. So in this case, in some cases there may be questions of material fact to go to the jury. In this case, there simply are none.
Ms. Browning, does that conclude your argument?
I was just looking quickly through my notes, Your Honor, to see if there was anything else. Thank you.
Go right ahead.
And, Your Honor, I'll just say that this statute has been in place, the idea that there is not a discovery rule and that you look to the date of injury in Virginia has been in place for decades and decades. And as this court has said and other courts have said, that if that needs to be changed, it is up to the General Assembly to do that. The Virginia General Assembly clearly knows how to change the law, and it is elected not to do so. So it's the law in Virginia, and it's the law that, since it's substantive law, that needs to be followed. Thank you, Your Honors.
Thank you, Ms. Browning. Appreciate it very much. Mr. Moore, Mr. Martin, I'm sorry. Mr. Martin?
Thank you, Your Honors. Ms. Browning just said a moment ago that Dr. Alam's testimony was that in 2007 it was possible and probable that he had pneumoconiosis from a 2018 deposition. But when Mr. Adams was sitting in Dr. Alam's office in 2007, Dr. Alam told him that he only suffered from granulomatous disease, which is a fairly innocuous lung scarring that doesn't cause much damage. 2 years later, sitting in the same office, he tells Mr. Adams he's perfectly healthy, still has this granulomatous problem. That evidence
from the medical records?
Yes, from Dr. Alam's direct examination that I took. The problem is, if you look at Dr. Alam's testimony, the direct examination is in real time at the time the diagnostic information was obtained and given to the plaintiff. The cross-examination is a retrospective examination based upon everything that Dr. Alam knows up until the point in time he was deposed. That's a very important point. No deference was given to the conclusions rendered to Mr. Adams at the time he was treated. And because the trial court erred because it failed to give any weight to that evidence, and when you look at that evidence properly, Mr. Adams was not diagnosed in 2007. He was not told that, and he could not have been expected to anticipate that he was going to get it at some point in the future. And at the very least, that debate is a matter of factual dispute between the parties. If we apply, yes, Your Honor.
This is Judge Clee. I understand the argument you're making on that front. How do you reconcile Mr. Adams being designated as a Part 90 minor with Dr. Alam's, if you will, lagging diagnosis of him suffering from occupational pneumoconiosis?
Well, Part 90 designation is a question of exposure. When MSHA recommends that you get into lighter exposure because you have the scarring on the lungs. But under the federal regulations, we also know that scarring is not diagnostic of pneumoconiosis. And so you have to look at it. The patient is making a choice when he goes Part 90 to reduce his dust levels. That's a good thing anyway. And he testifies, and it's in the record, that he made Part 90 decision not because he thought he had pneumoconiosis, but because he thought that was just the best choice for his family under the circumstances and the job that he was being offered. And again, that would be a factual dispute. It's disputed by Mr. Adams himself, just as it's disputed by Mr. Adams that he ever told the doctor that he had pneumoconiosis. He testifies he never told the doctor he had pneumoconiosis. Again, that would be a factual dispute. But if I look at to carry the argument of the defendants to its logical conclusion, one would have to file a case for pneumoconiosis 5 years before he was diagnosed, even if he didn't know he had it, because a retrospective analysis lets us, with more medical information, actually pinpoint someplace back in the past, as we can with all diseases that all of us old guys get, including myself. We can always pinpoint further back when we actually thought it started, when we have more medical information and as time passes. But if that was the law, then there would be no standard in Virginia. And there is a standard, and the standard is stated by Locke. And Locke specifically says that the statute of limitations is to be established, quoting again from page 905, quote, from available competent evidence produced by a plaintiff or defendant that pinpoints the precise date of injury, and here's the kicker, with a reasonable degree of medical certainty. So the evidence that has to be offered is where, before October 2014, is a statement by any physician to a degree of reasonable medical certainty that Mr. Adams has pneumoconiosis. It's not there. There's symptoms that are all attributed to other non-occupational causes. And the defendant's reliance on Joyce is misplaced as well, because Joyce involved pinpointing a particular characteristic of asbestosis, which is unique to that illness, pleural plaques. Everyone knows the pleural plaques, according to the medicine, is caused by asbestos, and that is something uniformly that triggers the statute. There's no such pinpointing evidence. Shortness of breath caused by heart disease, shortness of breath caused by pneumonia, lung scarring caused by granulomatous and histoplasmosis. These are the discussions that are flowing in and out of the record up until 2014 when the massive conglomeration is discovered. Those that ebb and flow in the medical records leaves Mr. Adams not knowing what's wrong with him. And the suggestion that under the regulatory framework, in order to even get a diagnosis of co-workers pneumoconiosis, you must file a black lung claim, because under the federal regulatory scheme, a black lung claim will not be accepted by a private doctor. So you file a claim to figure out whether you got it. He filed a claim and learned he had it as a result of that black lung process on October 2nd of 2014. That is when the statute began to run. To suggest that it is any time earlier requires a crystal ball, which the plaintiff, Mr. Adams, didn't have. We believe that at the very least there's a genuine issue of material fact here, and we would respectfully request the court reverse the trial court and remand for trial.
Thank you, Mr. Martin. We appreciate it very much, the arguments of counsel, and that will conclude this case. Madam Clerk.
Yes, sir. This court will take a brief break before hearing the next case. I will be ending this conference and calling all of the judges back after I get the second set of attorneys on the line.
Thank you very much.
Thank you.
Everyone.
Thank you, Your Honors.
Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Mr. Marazzo?
Yes, Your Honor.
Would be pleased to hear from you, sir. And tell us first who you represent here, would you please?
Yes, sir. May it please the Court. David Marazzo, on behalf of the appellants, U.S. Home and Lennar, whom the parties have collectively referred to as Lennar in the brief. I would like to address... Pardon me.
Go right ahead.
I would like to address first expert fees. Maryland law follows the American rule with respect to fee shifting. Parties are responsible to pay their own attorney fees and their own expert fees, regardless of outcome, unless a contract, statute, or rule expressly provides otherwise. In Maryland, courts must strictly construe a fee-shifting contract to avoid inferring duties the parties did not intend to create. The question presented on appeal is whether the purchase and sale agreement explicitly and unambiguously provides for expert fee shifting. The district court answered affirmatively, and we respectfully submit that decision is reversible error.
Mr. Marazzo, if the language in the contract is the prevailing party shall be entitled to recover costs, fees, and expenses, including actual and reasonable attorney's fees, what type of fees other than attorney's fees do you believe are included in this fee shifting provision?
None, Your Honor. Just attorney's fees. And I will address that directly because I believe that was the district court's
Judge King, but your answer would mean that that including language is surpluses.
Yes and no, Your Honor. Including clauses oftentimes are surplusage, but the inference that it does no work is equally plausible. It also applies under the district court's interpretation. Let me explain what I mean. If the first provision, the provision that says all fees, costs, and expenses included every type of fee, then the including clause, meaning including attorney fees, that would do no work. That would be surplusage. And somebody might say, well, no, it doesn't do surplusage. It is being very clear to call out a particular type of fee, attorney fees, so that there's no ambiguity, no lack of clarity that attorney fees are one of the types of fees that are included. Well, if that type of clarification was necessary and appropriate for attorney fees, it would be equally necessary and appropriate for expert fees, given the American rule. And that's an important beginning foundational point under the language of the agreement. This agreement, and the section that Your Honors just quoted, explicitly authorizes recovery of attorney's fees, as we all know. Equally undisputed is that the section never uses the word expert, consultant, or experts or consultants' fees. Had the parties intended to provide for fee shifting of experts, they easily could have called out experts or consultant fees as they did with attorneys. We believe the omission from the prevailing party provision was intentional. And we know that from Section 8 of the same agreement, which, Your Honors, it appears at page 574 of the joint appendix. That provision is titled Costs, and it states in relevant part, quote, except as otherwise provided in this agreement, each party shall be responsible for its own attorneys and other consultant fees and expenses. Thus, each party shall be responsible to pay its own attorneys and its own consultants unless the PSA provides otherwise. And both attorneys and consultants are called out by category. Section 18A does, 18K, does provide otherwise, but it only identifies the category of attorney fees. It says nothing about experts or consultants. Now, importantly, neither the district court nor ISTAR cites any case applying Maryland law where a prevailing litigant was reimbursed for expert fees, where the word expert or expert fees is not explicitly included in the fee-shifting provision. We are aware of none. In contrast, we cited Berkeley Trace at pages 14 and 15 of our brief. In that District of Maryland case, the operative agreement provided plaintiff's landlord could recover, quote, from tenant all costs incurred by the landlord, including reasonable attorney's fees and such costs. Though the agreement there provided for the recovery of all costs, including attorney's fees, the court held it did not provide for the recovery of expert witness fees. And that was because the same inference that I just described earlier in response to Your Honor's questions was equally plausible there. Although the expert fees expended by the plaintiffs may have been necessary and reasonable, the court noted, in the absence of explicit contractual mention of attorney fees, there was no legal basis upon which to award those fees.
Is that your best case, you think?
I do think that's our best case with respect to the fee shifting of expert fees under a private contract. We do think there's a relevant Fourth Circuit case, but that deals with statutory fee shifting, and that case is called Wheeler, 585 F. 2nd, 618. And that case is cited and examined in the case that the district court relied on called Mid-Atlantic Toyota. In that case, that was a class action antitrust settlement where, as part of the settlement, plaintiff's counsel requested that a portion of a settlement fund be allocated to reimburse plaintiffs for their expert fees. And the question was whether the statute provided for reimbursement of expert fees, even though the statute only says attorney fees. And the district court in that case, now we think that particular situation is an apposite here, as mentioned in the briefs, because it's dealing with statutory interpretation, not with private contracts. But to the extent it is an applicable analogy, in that case, the district court held that even though the statute did not provide for the word expert, this district court would. And on that point, the district court acknowledged the Wheeler case that I just cited, that, quote, outside non-legal consultants and experts are traditionally not regarded as attorney fees, however essential their services may be to the successful preparation and trial of a complex case, and therefore may not be recovered. The district court in Toyota, notwithstanding acknowledging this court's Wheeler decision, nevertheless departed from it, believing that an intervening Eighth Circuit case called Paschal reflected a trend in the law. We do not believe the district court had authority to depart from this court's decision in Wheeler, and it was not appealed. No en-banc panel or other panel of this court has reversed or criticized Wheeler, and indeed, subsequent cases, including Davis versus Richmond, 803 F. 2nd, 1322, reaffirm the Wheeler holding that expert fees are not compensable under statutes unless they explicitly provide for it.
Mr. Moroso?
Yes, Your Honor.
This is Judge Klee. Can you explain for me, perhaps a little more detail, what I would call your argument to bootstrap the definition of costs? I believe you mentioned it's defined in paragraph 18 to the relevant prevailing party provision at issue here.
Yes, Your Honor. The two sections that I think are important to juxtapose are Section 8, which is entitled Costs, and Section...
Sorry, I said 18. I apologize.
No problem. And Section 18K, which is the prevailing party provision. Under Section 8, what you'll see is that's titled Costs, and in the middle of that provision, with the sentence beginning except, it states, except as otherwise provided in this agreement. Each party shall be responsible for its own attorneys and other consultants' fees and expenses. So what that does, in our view, under the PSA Section 8, that is really just memorializing the American rule that the parties will pay for, will shoulder, will bear the cost of their own attorneys and their own consultants, unless provided otherwise in the agreement. So does the agreement provide otherwise? We acknowledge that it does in Section 18K. In 18K, it specifically states that attorney's fees shall be reimbursable, but it does not say consultants. So in one section, they state the parties shall bear their own attorney's fees and consultants' fees, and in another section, it says that attorney's fees shall be compensable, and it is silent with respect to experts and consulting fees. That juxtaposition, we believe, must be respected.
Okay. I understood, but with respect to Section 8 of the agreement, which, at least in my copy of the appendix, is on page 574 of the joint appendix, that does not reference litigation, correct?
It is not reference litigation. It is not limited to litigation. It would be any attorneys or any consultants.
Okay. All right. Understood. Thank you very much.
The district court also held that Lennar is required to pay the attorney's fees incurred for work performed on behalf of 3 companies, the seller companies who were litigants to the lawsuit below. We believe the district court erred here as well because the seller companies are not parties to an agreement with a fee-shifting provision. As an initial matter, it's undisputed the seller companies submitted no motion for fees, filed no objection to the magistrate's report, filed no notice of appeal, and submitted no brief to this court. If the seller companies believed they had a contractual right to reimbursement of their fees, they had an obligation to file a motion to recover them. By failing to do so, the seller companies waived their claim to reimbursement. But as noted in the briefs and just now, the seller companies did not file a motion for fees. Instead, another litigant, Stephen Sandler, asked the court to award him the fees incurred for work performed on behalf of the seller companies. Sandler argues he is entitled to the seller company's fees under the so-called guarantee agreements, which are located at pages 1431 and 1434 of the joint appendix. We submit that that argument is foreclosed and rejected by this court's June 2020 decision in Parkway 1046 versus U.S. Home Corp., which we brought to Your Honor's attention via a notice of supplemental authority. Parkway concerned the same Maryland property and transaction that is at issue in this case. Parkway was a third-party beneficiary of one of the underlying contracts, successfully sued Lennar, and sought reimbursement of attorney's fees. This court observed that although Parkway was a prevailing litigant, it was not a party to the underlying contract with a fee-shifting provision, and therefore had no right to reimbursement of its fees. The court acknowledged it was a very straightforward analysis, and we believe that straightforward analysis applies here. The selling companies are not parties to either guarantee agreement. But Mr. Sandler says not so fast. He says, I am a party to the guarantee agreement. I prevailed in the litigation below, and I am the one seeking reimbursement of fees. In short, Mr. Sandler contends he should be able to recover indirectly what the seller companies cannot recover directly. According to Mr. Sandler, this court should disregard the fact that the seller companies have no contractual right to fees because he has a contractual right to fees. He agreed to front their legal bills, and their interests and his interests were aligned in the underlying suit. Mr. Sandler cites no...
They maintain a uniform position, right?
Yes, Your Honor, they did maintain a uniform position. Mr. Sandler cites no case, and we know of no case, in which the American rule was disregarded based on an alignment of interests among litigants. Mr. Sandler cites no case, and we know of no case in which a court awarded one litigant, like Mr. Sandler, the fees incurred on behalf of another litigant, the seller company, because their interests were aligned. If left undisturbed, we believe the district court's holding would represent a sweeping revision of the law. It would upset the settled expectation that parties bear their own attorney's fees absent a clear, unequivocal contract saying otherwise. And perhaps worse, we think the rule could be abused in future cases where, quote, aligned litigants could make inter se agreements between them about their legal fees that would unilaterally expand the obligations of the opposing party, but not increase their rights. To be clear, Your Honor, Lennar does not argue that Mr. Sandler waived his contractual right to fees by hiring one law firm to represent him and the seller companies. Our position is that Sandler is entitled to exactly what he negotiated in the guarantee agreement, no more and no less. And we submit that the language of those agreements entitles him to recover fees if three conditions are met. One, the work in the litigation is performed on Mr. Sandler's behalf. Second, the work is performed for claims brought under the guarantee. And third, he prevails. The third condition is not in dispute in this case. Conversely, Mr. Sandler is not entitled to recover fees for work performed on behalf of the seller companies or for work on claims not brought under the guarantee agreements. Yet it is undisputed. I will reserve the balance of my time for rebuttal. Thank you.
You can finish your sentence there. We don't stop you in the middle of the comma.
Okay, thank you very much, Your Honor. My sentence was, it is undisputed that Mr. Sandler does indeed seek reimbursement for fees that do not meet one or both of these contractual requirements.
Thank you very much, sir. Mr. Robley, are you next?
Yes. Thank you, Your Honors. Good morning, and may it please the Court. Colin Rabley for Appalese, Stephen Sandler, Settlers Crossing, Washington Park Estates, and Bavard Development. I will be using 10 minutes of Appalese time. Mr. Chapiga will use the remaining 10 minutes on behalf of Appalee iStar. During my argument, Your Honors, I will refer to Settlers Crossing, Washington Park Estates, and Bavard Development as Mr. Sandler's companies or the companies. Your Honors, this appeal arises out of a decade-long plus dispute that began when, as this Court concluded 3 years ago, Lennar breached a real estate agreement with the companies in bad faith and then sued them and Mr. Sandler, who had guaranteed the company's obligations to Lennar. After years of litigation, this Court affirmed a judgment in that lawsuit against Lennar and in favor of the companies Mr. Sandler and iStar. Mr. Sandler proceeded to seek attorney fees defending himself and his companies in that suit under a fee provision in the guarantee contracts that he had entered into with Lennar. The District Court properly awarded Mr. Sandler those fees, Your Honor, based on its findings, one, that Mr. Sandler was a prevailing party in the lawsuit brought by Lennar, two, that Lennar brought that lawsuit against Mr. Sandler under the guarantee contracts, and three, that the fees awarded, including any fees Mr. Sandler incurred defending his companies against Lennar's claims against them, were, in the words of the guarantee contract's fee provision, reasonable. Lennar does not dispute any of these findings in its opening brief on appeal. That is a waiver and that alone supports affirmance, Your Honors. The District Court concluded that the fee provision's term...
What do you say they waived?
Your Honors, they don't challenge the District Court's interpretation of reasonable attorney fees, in our view. That was the crux of the District...
Does that apply to the amount of the fees for the companies, or does that apply to some other attorney fees also?
That applies to the entire award, Your Honor.
That's the $15 million or something?
No. Excuse me. That is the entire award to Mr. Sandler, not to iStar.
All right.
Your Honors, the District Court interpreted that phrase.
Are you involved in the expert witness dispute also?
No, we are not.
You're not. You don't have a dog in that hunt. Okay.
Correct.
All right. You're just talking to Mr. Sandler's attorney's fee. All right.
That's correct. Under the guarantee contracts, that's what I'm addressing right now, Your Honor.
Very good.
The crux of the District Court's opinion, Your Honor, was its interpretation of reasonable attorney fees and its conclusion that the fees Mr. Sandler incurred defending his companies against Lennar's claims in the underlying lawsuit were included in that interpretation. That conclusion was based on the fact that if the companies were found liable in that lawsuit to Lennar, Mr. Sandler would have been liable as the company's guarantor, a fact Lennar does not dispute. Lennar cannot point to anywhere in its opening brief where it disputed the district court's interpretation of reasonable attorney fees or offered a counter-interpretation of that dispositive language. What Lennar does say, that it did enough to avoid waiver simply by arguing that Mr. Sandler has no quote-unquote right to the company's fees, is not responsive to the question of the meaning of reasonable attorney fees. Rather, it is circular. Mr. Sandler has a right to those fees precisely because they are reasonable. Lennar also claims that it challenged the district court's interpretation of reasonable when it argued that Mr. Sandler could only recover fees spent defending his companies in his own pleadings, but not fees spent on his company's pleadings. That is not an argument challenging the meaning of reasonable attorney fees either. And on page 18 of its reply brief, Your Honors, Lennar in fact concedes that Mr. Sandler, quote, needed to show, unquote, that his companies were not liable to Lennar. Because of Lennar's waiver, the court should affirm the award to Mr. Sandler on that basis alone. As for the merits, Your Honors, of the fee award to Mr. Sandler under the guarantees, we submit the district court's ruling follows from the plain language of the fee provision, the undisputed record, and Mr. Sandler's guarantee of his company's obligations. As noted, under the fee provision, a prevailing party in any litigation between Mr. Sandler and Lennar is entitled to, quote, reasonable attorney fees and costs of suit, unquote.
Mr. Wadley, let me ask you this. If the sellers could recover independently, then do you believe the purchase agreement allows for duplicative recovery?
Well, that's a different basis, an alternate basis for the award, Your Honor. And I assume what you mean is, are you referring to iStar?
Yeah, well, do both sellers and iStar retain rights to attorney's fees?
Your Honor, first, let me say that that is an alternate basis for the fee award. We believe, as we have argued, that the guarantees provide an independent and sufficient basis for the entire award to Mr. Sandler and his companies. Alternately, the district court also found that the companies retained their own right to fees under the purchase agreement. And I believe what Your Honor is referring to is Lennar's argument that if that award under that contract just to the companies is upheld, that would somehow create duplicative rights to fees with iStar. Lennar made that assertion in its opening brief, Your Honors, but our position is it didn't develop the argument beyond a cursory assertion, which is not sufficient to raise the issue under this court's precedents. But addressing the merits of that issue, there would be rights on behalf of both the companies on the one hand and iStar on the other under the same agreement. But the district court found that that was acceptable based on the specific facts in the record here, Your Honors, that are undisputed and that Lennar avoided discussing in its opening brief, which is yet another waiver we would submit. Lennar disputes the district court's conclusion, but it never addresses the basis for the court's reasoning of its alternate award under the purchase agreement. And that was that although the companies defaulted on the iStar loan, which otherwise affected an assignment of their rights under the purchase agreement, because that default indisputably was caused by Lennar's bad faith breach, employing Maryland contract principles and finding a fair and reasonable interpretation of the purchase agreement under those facts would allow the companies to recover fees on their own under that purchase agreement. We submit that that conclusion is correct, Your Honor, but again, we believe and we know that the district court's principal basis for the award to Mr. Sandler was under the guarantees. Your Honors, I'd like to return to my discussion briefly of the guarantee contracts and why they support the award to Mr. Sandler. As I was saying, there is no dispute that Lennar sued Mr. Sandler under the guarantees or that Mr. Sandler is a prevailing party in that lawsuit. Moreover, as Mr. Sandler's trial counsel attested below in the district court, and Your Honors, this can be found at Joint Appendix page 402, Mr. Sandler did not seek any fees not, quote, attributable to the claims against him, unquote, including fees spent, for example, on his company's counterclaims against Lennar. To be clear, Mr. Sandler did not seek fees spent on the counterclaims, nor did the district court award them. The only remaining question is whether fees awarded to Mr. Sandler incurred defending his companies were, quote, reasonable attorney fees, unquote, of the suit in which he and Lennar were parties. A suit, by the way, in which by Lennar's own choosing, the companies were parties as well. We submit the fees here were clearly reasonable. Lennar sued Mr. Sandler's companies to recover a $20 million deposit. Lennar, would it be okay if I finish my sentence, Your Honors?
Absolutely. Absolutely.
To recover a $20 million deposit Lennar made in connection with the underlying real estate transaction plus interest. Thank you, Your Honors.
Thank you very much, Mr. Robley. Is it Chapika?
Good morning, Your Honors. This is Jeffrey Chapiga, and I represent defendant Appley iStar, Inc. May I proceed?
Yes, good to have you here with us, Mr. Chapiga, and we look forward to your argument. You proceed.
Thank you. It's good to be with you. I'm going to be addressing the expert issue that Mr. Moroso started with this morning. Following a decade of litigation, iStar sought fees and costs and expenses under the broad loser pays provision, Section 18K of the parties' purchase agreement. In a painstaking review, the district court awarded iStar over $12 million in fees, costs, and expenses under Section 18K. Now, Lennar concedes that the vast majority of that was correct, but now appeals from $656,000 of that $12 million, claiming error in the award of expert witness fees and costs. Experts were essential to the trial below. It was a battle of experts. iStar's expert fees and costs are clearly compensable under the broad loser pays provision at issue here. And I think it's important that we focus on the exact language of this agreement at Section 18K, because the other side cites several cases about general presumptions, but the other cases construe other contracts and refer to language that isn't at issue here. Here, language says, in the event of any litigation arising under or pursuant to this agreement, the prevailing party in such matter shall be entitled to recover from the non-prevailing party such party's costs, fees, and expenses incurred in such litigation, including actual and reasonable attorney's fees and court costs. The district court properly found that this broad language encompassed the fees that iStar had to go out of pocket to prepare and put on expert evidence at trial. Lennar argues that because the word expert doesn't appear expressly in this provision, expert fees can't be awarded. But that's not a fair interpretation of Maryland law, and it's an implausible reading of the word of this contract, and each of those words must be given a plain meaning.
Excuse me, I apologize for interrupting you, Mr. Chapiga, but the sound is pretty bad. Can you try maybe, I don't know, are you right near the speaker?
Yeah, is that any better? Let me raise the volume a little bit. Is that any better?
It's very choppy. Say something again.
Hello, Madam Clerk, this is Jeff Chapiga from...
It's not any better.
Would you prefer to call me back on another phone number?
I'm not sure. Are you on speaker right now?
I am not on speaker. I'm on my landline. I can hear you. You can't hear me on this?
Judges, does Mr. Chapiga sound choppy?
He does sound choppy. I can hear him, but he's breaking up a little bit.
I can try calling you back on a different line very quickly, unless you want to continue, Judge. It's up to you.
I'd say call him back.
Yes, sir. Okay, everyone, hold while I call him back, please. Mr. Chapiga, I'm gonna hang up and call you back. Okay?
Oh, okay.
And do you have a different line number? I might need that number.
Sure. It's 917. 463 6955.
Okay, thank you.
Thank you.
Okay.
I was talking about the specific language at Section 18K here, which is the operative provision, which says that prevailing parties shall be entitled to recover costs, fees, and expenses incurred in such litigation. And Lennar's argument is that because it doesn't specifically mention the term expert, you can't imply that experts are covered. So that's not a fair reading of Maryland law, and it's not a fair reading of this contract or the English language. In Maryland law, it says that each word in the contract must be given a plain meaning, and as the court rightly noted, Lennar's interpretation of this contract would leave the general term fees right out of the contract. It would be surplusage. This is a loser pays provision that reverses the American rule and entitles my client iStar to recover all of its costs, fees, and expenses. Now, Maryland law says that fee shifting provisions are valid and enforceable, especially between sophisticated parties like the one here. And in construing any contract, including a loser pays provision, courts must give effect to the plain meaning. And the question is, what would a reasonable person understand the words of a contract to mean? Here, the reasonable person would understand the words of the contract to entitle iStar to its fees and costs incurred in the litigation. And there's no carve-out for experts. Lenars cites this case, Berkeley Tracing. I believe one of your honors asked if that was the best case, and Lenars counsel said, yes, that's our best case. That case construed a very different provision. And I think if you look closely at the opinion in Berkeley Trace, you'll see it's very different from the case now before the court. And I'd like to turn your Honor's attention to one of the key passage in Berkeley Trace. And this is 2013 WL 57-18867 at SR 10. The court in Berkeley Trace said, the lease between the parties in this case states that the plaintiffs may recover, quote, costs, but doesn't provide for the recovery of expert fees. Although the expert fees expended by the plaintiffs may have been necessary and reasonable, this court has no legal basis upon which to award those fees. So the court there was construing a provision that awarded costs. It was not construing this provision that awarded fees, costs, and expenses. Lenars counsel pointed out that we don't have a particular case on point, and that's because cases that involve provisions like this simply don't litigate it. The loser pays the fees and costs. Doing the Westlaw search for these particular words in this contract, you come up with lots of cases where the loser has paid expert fees. The issue isn't even litigated because it's clear that where the contract provides for fees, expert fees are just included. And there are numerous cases like that. If you search the federal reporters, I would refer your honors to INRI RFC of the District of Minnesota. That's 399 F sub 3rd 827 2019 as just one example where a broad provision like this encompasses expert fees.
Mr. Chapino, what if any help does NRA Mid-Atlantic Toyota do for you?
I think it's an important case to show that expert fees can be included as attorney's fees. They can be included here. There are three provisions, right? We get fees, costs, and expenses. And I think expert fees could be understood as a part of all three of those. And the Mid-Atlantic case is a case where attorney's fees was construed to include expert fees because they were essential and critical to the litigation of the case. And I think that's the case here, too, where our experts were so central to this defense. This was really a battle of the experts.
Mr. Chapiga, this is Judge Klee. I had asked Mr. Moroso about the appellant's argument that somehow Section 8 of the Section 8 of the contracted issue limits Section 18. I wanted to give you a chance to provide your thoughts on that.
Yeah, I appreciate that, Your Honor. I think Your Honor's question towards the end, Mr. Moroso, is absolutely on point. That has nothing to do, Section 8 has nothing to do with litigation. It's the general provision about costs and attorney's fees. And indeed, you know what, Mr. Moroso kept talking about the heading that it's called costs, even though the contract says that the headings are just for convenience and reference only. But in any event, Section 8 just talks about costs. It is not on point here. The on point section of this contract is Section 18K, which is a carve out that says in the event of any litigation, and we're clearly in the world of Section 18K here, and 18K reverses the American rule, and 18K reverses whatever presumption Mr. Moroso suggests there is from Section 8. And I think it's important that Lenar's own arguments betray its position here. In the district court, when we saw fees and costs, there are lots of fees and costs that they didn't even object to, including e-discovery fees or the fees and costs for court reporters, witness fees. These are all fees that we saw and that the district court ordered the other side to pay. And I think it's important because not all of these specific kinds of fees and costs are going to be included in the words of the contract. It's implausible to suggest that the parties have a burden to go in detail each kind of fee and cost that should be included, especially when the general nature of this provision is reversed to the American rule.
Much detail if it just said and including witness fee, expert witness fee.
Well, Your Honor, the parties
you head this whole thing off.
there should be no burden
And this is,
at the
that's a pretty
outset.
close question. I mean, the magistrate judge ruled against you, and the district court district judge reversed the magistrate judge. But she said that the expert fees are essential to the litigation. Were essential to the litigation, and they're included. My question is, I'm getting around to it. Do we give any deference to the district court's view on that point?
Your Honor, I think the district court's view on that point is very important. Most of the trial opinion, Judge doesn't have 75-page opus here, is devoted to going into the experts.
Well, let me ask you this: do we review her position that they were included for abuse of discretion, or do we review it de novo?
The contract interpretation is de novo, Your Honor. The fact question of whether they were
we don't get any deference to it. And the answer is we don't give her view of it any deference.
That's right, Your Honor. The legal question of what standards are under Maryland law. And under Maryland law, but giving full effect to each of the words of the contract, we believe it clearly provides for the expert fees. So, Your Honor, I think the parties here contracted to a broad user pays regime. It includes cost, fees, and expenses. There's no sense to carve out particular kinds of fees or put an onus on the parties to imagine all the various types of fees and expenses that may incur in hypothetical litigation 10 years down the road when they're contracted. Here they just agreed to the cost, fees, and expenses and to put the burden on the non-prevailing party. iStar has to go out of pocket to pay $656,000 to defend itself at trial. iStar, under the express terms of Section 18K, should not be the party that has to bear those now. The district court got this issue right, and its decision should be affirmed.
Thank you very much, sir.
Yes. Thank you, Your Honor.
I think I heard the bell go off. We appreciate your views on the matter. Mr. Marazzo, did you reserve some rebuttal time?
I did, Your Honor. 5 minutes.
Very good.
Thank you, Your Honor. I'll start with expert fees again. I want to be clear that we do not contend that the district court's interpretation of this agreement is implausible or impossible. The district court's interpretation that the including clause is merely illustrative of the type of fee that might be shifted is a reasonable interpretation, as the district court found. But it is not the only reasonable interpretation, as the magistrate judge found. The other plausible interpretation is that the including clause is limiting. It is a clause that limits the type of fee that is recoverable. And because the provision is subject to two reasonable, plausible interpretations, it is not sufficiently explicit to reverse the American rule. That is the point that we're making. When a provision is subject to two interpretations, it's not sufficiently clear. And Your Honor asked a very important question about deference. This is a contract interpretation, and the district court's determination is not entitled to deference. I do want to address quickly the idea that expert fees are routinely awarded and that this is not an issue that is litigated. There are cases under Maryland law where expert fees are awarded. But in each of those instances, the contract language at issue explicitly included expert fees. Beck versus Sullivan, 2013, Westlaw 5531389. The contract says that the prevailing party is entitled to the cost of suit and any appeal, including reasonable attorney fees, expert fees, and court costs. Peterson versus Springdale, 2018, Westlaw 4502286. Same result. The prevailing party in any action shall be entitled to reimbursement of their litigation costs and expenses, including attorney fees, expert fees, and court costs. That's what this agreement lacks, and it's why the decision should be reversed. As to the question about Mid-Atlantic Toyota that Your Honor asked, we believe that case is not good law, that Wheeler is good law, as affirmed by Davis and subsequent cases. On the Sandler fees issue, Your Honors, we do not believe we waived anything. The entire premise of our objection of the magistrate's report and of this appeal is the issue of whether Mr. Sandler is entitled to recover the fees incurred on behalf of his companies and on claims that were not the subject of the guarantee agreements. It's an issue of entitlement, not necessarily reasonableness. And in any event, it would be inherently unreasonable and contrary to law for a court to award any fee that is not covered by a fee-shifting provision. Now, Mr. Rabley said that Mr. Sandler does not seek any reimbursement for fees incurred on behalf of the seller companies or for claims that were not the subject of the guarantee agreement. We just think there's a factual dispute about this. The record is ECF 804-3. We cited this to the district court. There are literally dozens and dozens of entries that concern, for example, the counterclaim that the seller companies filed affirmatively against our client, Lennar. Mr. Sandler was not a party to those counterclaims, and those counterclaims were brought pursuant to the purchase and sale agreement, not the guarantee agreement. Likewise, there are dozens and dozens of entries, thousands of dollars in dispute, concerning the fraud claims that Lennar brought against the seller companies. Those claims were not brought against Mr. Sandler, and those claims were not brought pursuant to the guarantee agreement. And finally, with respect to the purchase and sale agreement, and whether the seller companies have an independent and direct right to recover fees pursuant to that separate contract, the answer is definitively no. The seller companies did not file a motion for fees, much less a motion for fees pursuant to the purchase and sale agreement. iStar did. The district court's interpretation that Mr. Rabley described, that because Lennar breached first, it somehow divided and duplicated the rights under the agreement, we believe is irreconcilable with the language of the agreement. This is at the joint appendix, pages 1123 through 27, which lists 21 separate events of default. One of those is Lennar's breach, and that particular conduct would not be considered an event of default. But there are 20 other events of default. And Section 9.1 of the agreement says that an event of default shall be defined as, quote, one or more of the aforementioned events. Here, as iStar's own brief states, the fact that Lennar may have breached first does not mean there was not a separate event of default when the seller companies did not pay the loan. And this court, in its prior opinion, and the district court in multiple times found that there was an event of default in which iStar stepped into the shoes of the seller companies with respect to the purchase and sale agreement, which includes the right to recover attorney's fees. Thank you for your indulgence.
Mr. Marrazzo.
I'm sorry, I didn't hear you, Your Honor.
I think I heard your bell. Maybe I didn't hear it right.
Oh, you did. I said thank you, Your Honor.
Yes, sir. Thank you very much. We appreciate the argument and that of all the fine lawyers. And we'll take the case under advisement. And that concludes this argument, Madam Clerk.
The court will take a brief break before hearing the next case. Judges, I will call you back in a few minutes. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
I want to welcome the attorneys in our third case this morning, number 196626, Ward versus United States. Captain Miser?
Yes, Judge.
You are representing the appellant, are you?
Yes, that's correct, Your Honor.
And are you an Air Force officer? Is that the captain title?
I'm an active duty Navy officer at this point, Judge.
Active duty Navy. Well, I'm what, captain of the Navy. You're an 06.
That's right, Judge.
Very good. Good to have you here. And we'll look forward to your presentation. You may proceed.
Thank you, Your Honor. And may it please the court, Brian Miser on behalf of Joseph Ward III. Through the Uniform Code of Military Justice, Congress authorized Captain Ward to be tried by a panel of 8 military officers and to be convicted with the concurrence of 2/3 of those officers. But at the time of Captain Ward's court-martial and direct appeal, neither Congress nor any military appellate court had authorized those 8 officers to employ a preponderance of the evidence standard during their deliberations or to use one charged offense to prove another charged offense. The Court of Appeals for the Armed Forces, or CAF, has concluded that it was an obvious violation of basic due process for them to do so, and Captain Ward received the ineffective assistance of counsel on direct appeal when his military appellate lawyers failed to raise that preserved issue. What isn't in dispute, and there's a lot in dispute regarding Burns v. Wilson, but what isn't in dispute is that Captain Ward is entitled to de novo review where the military courts have manifestly refused to consider his claims as they have done here.
Well, this is a collateral proceeding. It's called coram nobis, but it's really like a habeas corpus proceeding, or it is a habeas corpus proceeding on 2241. And don't we give deference to the military proceedings like we would in a civilian court? We give deference to the state court proceedings.
Indeed you would, Your Honor, but as I suggested, while the meaning of what full and fair consideration is under Burns isn't entirely clear, Burns does make clear that if the military courts refuse to hear the matter, that Captain Ward is entitled to de novo review. And we believe that that's what happened here with the coram nobis petition that we submitted to the Air Force Court and then ultimately to the Court of Appeals for the Armed Forces. Because on the same day that the CAF denied Captain Ward's petition for coram nobis, in a case called United States versus Gray, the court held that Article 76, which is the UCMJ's finality bar, was a jurisdictional bar to petitions for coram nobis in the military courts. And the other thing that the court does that day, they deny the coram nobis petition in Gray. They also deny Captain Ward's coram nobis petition and the coram nobis petitions of 2 other airmen, Lewis and Jeter. And so where the military courts have divested themselves of jurisdiction, we believe that this court then proceeds, and indeed Burns says that this court proceeds with de novo review.
Captain, let me ask you this. The petition was fully briefed before 2 separate appellate courts, which denied the claim. Is it your contention that doesn't meet the full and fair consideration test?
Well, Your Honor, I think our primary argument is that when the CAF is saying that Article 76 bars coram nobis, that isn't full and fair consideration under any standard. But if the court moves past Burns and seeks to wade into what is quite accurately a circuit split on what the meaning of full and fair consideration is, we believe that Captain Ward can prevail under that standard as well. And we believe that the most accurate statement of what full and fair consideration is set forth in the D.C. Circuit's Sanford decision, which is a 2006 decision. Because remember that Burns is the last word from the Supreme Court on habeas 2241 petitions, but councilman is the last word from the Supreme Court 2 decades later in collateral attack petitions under 1331. And while the courts, Kaufman has said that full and fair consideration has meant many things to many courts, the Tenth Circuit's jurisprudence is in fact all over the map with respect to interpreting that phrase. But again, we think that councilman provides some illumination of what is reviewable on collateral attack in addition to Burns. On page 747 of councilman, Your Honor, you will see that the court says that Article 3 courts have jurisdiction to review courts-martial that are void due to lack of jurisdiction, and then importantly, or some other fundamental defect. And we believe that the violation of the presumption of innocence is clearly within the ambit of that other fundamental defect. Additionally, on page 753 of councilman, the court suggests that habeas review is broader than that discussed in councilman, where the court says, quote, grounds of impeachment cognizable in habeas proceedings may not be sufficient to warrant other forms of collateral relief. And then ultimately on that same page, the question of whether a court-martial judgment may be deemed void may turn on the nature of the alleged defect and the gravity of the harm from which relief is sought. We're dealing with very serious constitutional issues here. As I mentioned, the presumption of innocence, and then the Sixth Amendment claim relating to Captain.
But even if there's some kind of a violation here, it's all subject to harmless error review.
Your Honor, I believe that the CAF has applied constitutional harmless error review with respect to the Hills violation, if that answers Your Honor's question. So it would be harmless beyond a reasonable doubt is the standard that the CAF has applied when interpreting these prejudice under these cases. And so again, we believe that Sanford provides, it's a 2006 case from the D.C. Circuit, provides the court probably the most current and accurate synthesis of both Burns and councilman. With regard to the merits, Your Honor, underpinning the government's defense of both the due process argument and the Sixth Amendment claim is the government's assertion that this instruction that was given at Captain Ward's court-martial was entrenched by a litany of cases at the time of his court-martial. But as the government argued before the Air Force Court of Criminal Appeals, there was no settled law at the time of Captain Ward's direct appeal, and there was no reason why this issue wasn't raised. And that's the joint appendix at 116. In fact, dozens of other military attorneys were raising it at the time from every branch of military service. And we provided last week a 28J letter dealing with the only circuit opinion, I believe, to have addressed Hill's error, even if obliquely, in Evans v. Horton, which is 792 Federal Appendix at 571. And there, the petitioner was arguing that raising the error at the time would have been frivolous, and the Tenth Circuit concludes, on the contrary, as the government points out, litigants in other cases taking place around the same time as Evans's 2014 trial and 2015 appeal raised this very argument. And so it was deficient performance for Captain Ward's attorneys not to do the same thing that attorneys from the same office were doing at the same time. And we believe that Captain Ward falls in the ambit of cases where there is prejudice from that deficient performance.
But they had it in the recommended instructions book.
That's correct, Your Honor. So an Army pamphlet.
So obviously wrong. How did it end up in a recommended instructions book?
Well, Your Honor, that's a great question. I don't know that we're going to be able to get to the question of how the Army JAG School put it in its pattern instruction, what's called the military judge's bench book. But as I said, there's no military case that said that you could use a preponderance of the evidence standard or one offense to prove another offense. And with respect to the obviously wrong, beyond a reasonable doubt has been the standard.
The rules, the federal rules has a provision of what they call 404B, I think it is. That's pretty much a lay on to that, isn't it?
It is, Judge, and we in the military have the almost identical rules of evidence, with the exception of privileges, which are codified, unlike the federal rules of evidence. And so, had this evidence come in under 404B, that would have been a permissible use. But this came under Military Rule of Evidence 413, which also has a federal counterpart. And the CAF has held that it violates the presumption of innocence in the manner that it was used in this case. And beyond a reasonable doubt is the standard in courts-martial and has been since the Uniform Code of Military Justice was adopted May 1st, 1950. And so, however it came to be in the bench book, Judge, it conflicted with statute, and not a recent statute, a decades-old statute. And so the rule there was bolstered not only by the statute, but also the Court of Appeals for the Armed Forces' earlier decision in Wright, which six times...
I don't think, with the 404B jurisprudence of this circuit. I mean, we've proved those 404B admissibility issues pretty routinely, it seems to me.
Yes, Your Honor, and were this a case involving 404B, and had they set the foundation for one of the exceptions for 404B, we would only be dealing with one due process violation here. Remember, the CAF on page 357 says that there are two problems. One is this preponderance of the evidence that's going to the jury, and the second is using uncharged conduct to prove other uncharged conduct. And we'll concede that 404B allows that both in the military and in Article III courts, but that is not the issue or the rule that was invoked here. It was 413.
I understand. Go ahead.
Captain, how about comment on the retroactivity issue as to final convictions on a collateral challenge?
And so we think that there are two distinct constitutional violations here, Judge. One is the Sixth Amendment violation on direct appeal, where at the very least Captain Ward would be entitled to have his direct appeal voided and directed back to the Air Force Court of Criminal Appeals. But to your question, retroactivity under Teague, you don't go through the analysis unless something announces a new rule for purposes of Teague. And as I've alluded to earlier, there's nothing new about Hill's decision, and nothing in Hill suggests that it was anything than a reaffirmation of the CAF's 2000 decision in Wright. If you look at the Wright decision, you will see 6 references to the word uncharged. And indeed, the CAF in Wright, again in 2000, is looking to the legislative history for Federal Rule of Evidence 413, and that the framers of that rule intended for it to apply only to uncharged misconduct, not charged offenses in the same case. And so when Hills takes a look at this in 2016 and says that it's obviously constitutional, or to be very precise, obvious error, they reaffirm Wright and tell military litigants that we never said that this could be applied in charged cases. And with respect to the other aspect of the due process violation, beyond a reasonable doubt, as I said, is in Article 51 Charlie, and has been since May 1st of 1950. And in fact, with respect to Army practice, beyond a reasonable doubt has been the standard even longer than that, not in Navy practice, but in Army practice. And so we believe that Hills didn't announce a new rule. It would have been obvious to all jurists, notwithstanding the fact that it makes it into a pattern instruction that is signed off by an Army 06 at the Army JAG School in Charlottesville. With respect to, I think the final point that I want to make with respect to the military courts having closed their doors to collateral relief, we not only have Gray, but we also have the Willingbring case, which, if that sounds familiar, it's the same Sergeant Willingbring that has been before this circuit. And one of the issues not addressed by this court in the collateral review of his case was CAF's 1998 holding that death was still an authorized punishment for the crime of rape for purposes of the statute of limitations. CAF overruled that decision in a case called Mangahass in 2018, and so Willingbring then went back to the CAF, seeking to have the CAF enforce the fact that it had overruled the decision and the precedent in his case. And the order at 78 MJ 347 is directing Sergeant Willingbring, because of finality under Article 71 and 76, that he should raise his collateral relief in an appropriate forum. And so Willingbring, if he seeks to have the benefit of CAF's precedent in his case, has to go to an Article 3 court under CAF's current view of its limited jurisdiction. Ultimately, Your Honor, there's nothing that this court can do to compel the CAF to acknowledge its jurisdiction to review collateral attacks of court-martial involving fundamental constitutional error, but it can prevent a miscarriage of justice by voiding Captain Ward's court-martial and authorizing a rehearing in accordance with statute and the basic constitutional guarantees. Thank you, Your Honor.
Thank you, Captain Miser. Mr. Mesner, you're representing the government, correct?
That is correct, Your Honor.
Good to have you here, sir.
Thank you, Your Honor. May it please the court, Matthew Metzger on behalf of the respondent, the United States of America. A review of the merits by two appellate military courts, a disposition that relies on binding authorities that address the identical issues presented by petitioner, and two sets of thorough briefing. These are the hallmarks of the treatment that petitioner's challenge received in the military courts. This satisfies the Supreme Court standard that Article 3 courts examine whether the military courts gave full and fair consideration to petitioner's challenges. In light of this, petitioner may not relitigate challenges with de novo review in the Article 3 habeas court. The district court's judgment should therefore be affirmed for three reasons. First, the district court correctly determined that petitioner was not entitled to habeas relief because his petition for the writ of corvin nobis received full and fair consideration by the military court. Second, even if the court were to reach the merits of the issue fully and fairly considered by the military court, petitioner is not entitled to a retroactive application of the rule announced in Hills. Third, petitioner has not shown that his appellate counsel fell below an objective standard of reasonableness by failing to challenge an issue which, in the words of the highest military court, was a common understanding of the law. Turning to the first point, Your Honors, the Supreme Court has recognized that military law is separate from civil law because federal courts have played no development in the creation of military law and have never engaged in a supervisory role over the military courts to enforce military law. And as announced by the Supreme Court in Burns, the court stressed that it is not open to a federal civil court to grant a writ of habeas simply to reevaluate the evidence. Indeed, the Supreme Court recognized that in military habeas corpus, the inquiry, the scope of the matters open for review, has always been more narrow than in civil cases. It is for that reason, as this court recognized in Willingbring, that the review of federal habeas courts of court-martial decisions is limited to a determination of whether the military tribunal gave full and fair consideration to the issues presented. Or, stated differently, as my colleague has indicated, the inquiry is whether the military courts manifestly refuse to give considerations to the points raised. The respondent
did the military court, the last one, throw out this thing with a one-sentence order?
Your Honor, the Criminal Court of Appeals did generate a summarily dismissed this matter by saying that the writ was denied, but in doing so, it also just cited to two key authorities, United States v. Chapman and United States v. Lewis. And upon close inspection of those authorities, Your Honor, the respondent respectfully submits that those authorities were and address the issues, which shows that the jurists reviewing the petition understood the issues, recognized the authorities that controlled them, and rested on those authorities to rule on the matter. First, an examination of Chapman underscores that the writ of quorum nobis can only be available if there's no reason why the challenge could not have been brought sooner, which, upon close inspection of my colleague's argument, there is something to be said there. If it's truly the case that Hills did not announce a new rule and was really born out of precedent that was pre-existing at the time, this was an issue that could have been raised on direct review. So to take that issue and then present it in the petition for writ of quorum nobis is not appropriate. And then second, looking at Lewis, yes, there's part of that holding is explaining why quorum nobis is not available in the military courts, but there's also an alternative holding that directly addresses the issue that petitioner raised here, which is whether or not Hills is to apply retroactively. And the Lewis court held that it does not. And importantly, Lewis was a binding decision on the Criminal Court of Appeals, and it was decided one day before petitioner Ward's petition for writ of quorum nobis was denied. So the Criminal Court of Appeals had a one-day-old binding authority that controlled the results. So relying on that authority in its citation, in effect, I would submit, incorporated by reference the analysis laid there in the Lewis opinion into its order here, and that is why it ultimately denied relief in one sentence. So while it is admittedly a short opinion, it nonetheless understood it being the Criminal Court of Appeals, understood the issues presented, and gave them full and fair consideration. It was just that.
If they had written down everything that you just said, they'd have had a pretty good opinion. Yeah.
I think that's right, Your Honor.
You explained it pretty well for them. Yeah.
I think it's just a matter of efficiency. Otherwise, in effect, the jurists would be copy and pasting everything anew. And I think this court is well familiar that summary dispositions can be an efficient and effective tool to address matters when they're controlled by binding precedent. And so for that reason, the respondent respectfully submits that petitioner's challenge was given full and fair consideration. And as the court recognized in Willenbring, this inquiry is much more narrow. Now, to be sure, the inquiry can be broader on jurisdictional questions, but that's jurisdiction in a different sense. As the Supreme Court indicated in Councilman, it's jurisdiction of the military tribunal to exercise the court's martial outright, addressing issues such as whether or not the service member is actually an active member at the time. It also assesses whether the military tribunal had personal jurisdiction over the defendant at the time. So looking at Councilman, the fundamental errors that are void, ones that are to be given the greater review, are those that would void the judgment for res judicata purposes. That is the subject matter jurisdiction of the tribunal itself, as well as personal jurisdiction over the defendant. That is where the Article 3 habeas corpus review is plenary, and where it does diminish is on all other matters, where it's the inquiry is just whether it's full and fair consideration, and if the court is satisfied that full and fair consideration is to be given, the inquiry then ceases. And I think that is what Burns held in that plurality opinion. And the constitutional deficiencies raised in Burns are just as serious as the alleged ones here. It should be noted that in Burns, the petitioners were convicted of rape and murder and sentenced to death. And they had alleged that as a result of the pleadings, they were denied the basic rights to the Constitution. They had evidence. They alleged that evidence was planted. They alleged that the government coerced witnesses to testify against them, and that they were questioned without knowing their rights. So while Burns was decided before Miranda, I think that argument as described by the court in its opinion, it echoes in Miranda-type sentiments. So those concepts...
Let me ask you this. Should we treat the Burns test as a jurisdictional threshold, or that it just only affects the scope of review?
Your Honor, I would review Burns as being a question about the scope. I think the district court is obligated under 2241 and 1331 to announce that it has subject matter jurisdiction to entertain the writ. Moving past that, the next step would be through Burns is, okay, the writ is before me. What scope of review am I to apply? If the jurist assessing the writ, as well as what was considered in the military court's concern, was given full and fair consideration, I think that ends the inquiry. And at that point, I think it's a dismissal on the merits and not even a dismissal on for failure to state a claim. So I would not say that when the court concludes its review and says that they're fully in fair consideration, that a jurisdictional dismissal through the vehicle of 12b1 would necessarily be the correct disposition, but a dismissal because it fails on the merits would nevertheless be appropriate. And I do hope that has answered Your Honor's question. Your Honors, I'd like to turn now to the second point here regarding the retroactivity. I think, as my colleague pointed out...
Before you get to that, let me ask you this. Why are you not also arguing that even if he got past all the other things, they couldn't prove harmfulness anyway?
When you say prove harmfulness, is Your Honor asserting that?
Well, if we give the equivalent deference that we were given in EDSA appeal, we got to look to the state court proceedings and give them quite a bit of deference. Can we give that same equivalent deference to the military court?
Well, Your Honor, I think this is a question that was addressed in the Third Circuit's opinion, Armand, and I think the Third Circuit, in reading the relation between the military habeas review and state habeas review, concluded that they are not commensurate in scope, that in the military review is narrower than state habeas. So I don't think Your Honor has the opportunity to say, even if we found that this wasn't fully and fairly consideration, that it amounts to harmless error, because I think that would go outside the bounds of review authorized by Burns. And the Third Circuit's opinion that I referenced is 549 F. 3rd 279. And Your Honors, the retroactivity question, I think my colleague and I are in agreement that the question is that critique controls, but the question is, after that point, where do we go from there? My colleague asserts that Hills is not a new rule, whereas the respondent asserts that it does. I would respectfully note that Hills was a new rule. The court announced that the case was a matter of first impression, and that it understood interpreting military rule of evidence 413, that propensity evidence could be used by charged conduct and uncharged conduct to show that the defendant had a propensity to commit sexual assaults. And but at Hills, when Hills was decided, it said, in reviewing this interpretation of the military rule of evidence, it said that it held that the interpretation of using this propensity instruction for charged conduct did violate the presumption of innocence guaranteed by the Sixth Amendment. And I would just like to clarify the nature of this challenge here, especially in review of the military judge's charge on Joint Appendix 196 and 197. This is about the use of evidence of charged conduct to facilitate a propensity instruction. At all times, as evidenced by the military judge's charge, the panel or the jury was charged with assessing whether or not the government satisfied its burden that the offense was committed beyond a reasonable doubt. The jury was not excused of this obligation to say, as I understood my colleague to argue, was not excused of the obligation to find the defendant guilty based on a mere preponderance of the evidence. Indeed, the last sentence of page 196 into 197, I think, underscores the military judge's instruction to the panel to be clear that at all times that the standard of beyond a reasonable doubt must be met. And so, with that being the understanding of the error, and in light of Hill's holding new rule that the interpretation of the military rule of evidence was unconstitutional, the inquiry becomes whether or not this announced a watershed procedural rule such that it should apply retroactively. And the government would just note, Your Honor, that since the court announced the retroactive activity analysis in Teague, that no court that the Supreme Court has never invoked this exception to apply any rule retroactively, and so this should not be the first case that does so here. And the government would respectfully analogize the circumstances presented in this case as similar to the ones that the Supreme Court announced in Wharton, which addressed whether or not the court's decision in Crawford should apply retroactively going forward. And if Your Honors recall, Crawford held that testimonial hearsay, admitting that against defendant, violated the Confrontation Clause. And so the analogy here is that Crawford is that the military rule of evidence allowed propensity evidence to come in for charged conduct. Crawford, the rule prior to Crawford, said that testimonial hearsay could come in against the defendant, but since those rules changed, that type of evidence was no longer permitted. And in Wharton, recognizing that yes, while Crawford rested on the guarantees of the Sixth Amendment regarding the Confrontation Clause, that it nonetheless was not to apply retroactively. And we would submit that this case presents as a similar circumstance here, and that Hill should not be applying retroactively for the reasons also explained in the Criminal Court of Appeals decision in Lewis that was cited when denying petitioner's petition. Your Honor, I would just like to briefly note in response to the Rule 28J letter that we submitted, that there were challenges regarding jury instructions going on at this time, and reflects that it was understood that it was an error worth preserving, but it was ultimately a matter of judgment whether or not it should carry forward. Those challenges were being raised. It bears noting that they were all unsuccessful, and so in the wake of all these unsuccessful challenges, the government would submit it would be reasonable for petitioners' direct review appellate counsel to have the opportunity to forego that challenge in favor of others that she or he might deem might be more successful. And so, given this strategic choice in judgment, the respondent respectfully submits that petitioner's direct appeal counsel was not ineffective. And Your Honors, if you have no further questions, the respondent respectfully asks that you affirm the district court's judgment in all respects.
Thank you, Your Honor. With respect to, I'm sorry, Judge.
I say you have some rebuttal time, Captain Miser.
Thank you, Judge. With respect to the scope of review, because I think that is very important, obviously, for this court's resolution of the two constitutional issues before the court. We believe that the D.C. Circuit in Sanford provides a roadmap, if you will, of how this court should address it. And you can find that at 586 F. 3rd 32. And the circuit employs a two-part test. First, a review of the military court's thoroughness in examining the relevant claims, at least where thoroughness is contested, and it is contested here. And then two, a close look at the merits of the claim, albeit with some degree of deference, and certainly more than Kaufman's de novo standard. Here you have a summary order from the Air Force Court of Criminal Appeals, and with respect to my friend, I think it is citing the Air Force Court's opinion in Lewis, which did address those issues. But the CCAs, the Courts of Criminal Appeals, which are composed of 3 military appellate judges, are really the least important aspect of the military appellate system. And you see that reference in Noyd v. Bond and Councilman. The design of Congress really placed a lot of emphasis on the civilian judges at the Court of Appeals for the Armed Forces. And that's why we have really focused on the fact that that court has disavowed the jurisdiction of military appellate courts, and the CCAs are subordinate to that court to deal with quorum nobis and habeas corpus petitions post-finality under Article 76. Now, Judge, my friend has raised Armand versus McKeon, which held that Burns's standard was not implicated by EDPA when that statute was passed, and so full and fair consideration remains the standard, and more accurately, as the D.C. Circuit has held, full and fair consideration as illuminated by Councilman. And we know that there are fundamental errors that will be reviewed, according to Burns, in Article III courts, or that American servicemen and women have Article III courts available to them. I think we fundamentally disagree on the holding of CAF and its progeny with respect to the presumption of innocence. That is the holding of the CAF. We invite the court's attention to page 357 of Hills. We have also cited the Tovo Charez case in our pleadings, and also the Williams case, which is 77 MJ 460, where the CAF says, although our decision was not ambiguous, this is the third case in which we have had to correct a Court of Criminal Appeals judgment on this issue. And what is at issue is the foundational tenet, in the language of Tovo Charez. At issue here is appellant's right to be presumed innocent until proven guilty, a foundational tenet of the Fifth Amendment's due process clause, and a substantial right infringed upon by the erroneous instruction. As the CAF held in Hills, juxtaposing beyond a reasonable doubt with the preponderance of the evidence standard would tax the brain of even a trained lawyer. And in a system that already denies servicemen of rights, I mean, as we sit here today, American men and women in uniform are the only Americans that can be convicted by a non-unanimous vote. And all Hill says is that you can't stir in a preponderance of the evidence into those deliberations as well. We believe that that issue hasn't been addressed by the military courts, but even if this court were to hold otherwise, that the military courts haven't manifestly refused to consider those claims with these two truncated orders in Captain Ward's case, we believe that these are the fundamental errors that under Sanford, and it's not just the D.C. Circuit, the Ninth Circuit would even go further and have a de novo review. And I would also point out here that the Tenth Circuit, although invoked by the government, has not been entirely consistent either, with its most recent decisions in Rogers and Lips v. Commandant, the court's adopting a 4-factor test to assess full and fair consideration.
Captain, let me ask you this. Can this court look behind a summary dismissal to make assumptions about the military court's reasoning in denying the petition?
Your Honor, I think that's the problem, is when you have the court in gray say that Article 76 no longer gives the court jurisdiction for quorum nobis, and they deny Captain Ward's quorum nobis petition that same day, there's respectfully nothing to look behind. The courts have closed their doors to Captain Ward, and which is why he went to Article 3 court. But if you want to look further, if you want to look behind, as you say, Sanford gives that ability, that two-factor test. You examine the thoroughness of the military court's disposition, and you see that here, which is a one-sentence order, particularly from the Court of Appeals for the Armed Forces, and then you get to the merits of the claim, affording some deference, not as much deference in AEDPA, even under the Third Circuit standard. But once you do that, under both the Sixth Amendment and the Fifth Amendment claim, Captain Ward is entitled to relief. And I think the final point that I would make is that the courts, neither the Air Force Court nor the CAF, addressed the Sixth Amendment claim, that Captain Ward was denied his Sixth Amendment right to the effective assistance of counsel on direct appeal. At most, there is partial review of the Teague claim. And if there are no further questions, Your Honor, I appreciate the court's time.
Thank you, Captain. We appreciate it. We'll take the case under advisement and close out this call and move on to the next case, Madam Clerk.
Yes, sir. The court will take a brief break before hearing the next case. Judges, I will call you back The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Our final case of the day is number 19-1491. Mr. Jarrett, you're representing the appellant?
That's correct.
Please be pleased to hear from you, sir.
Thank you. There are three issues for the court's consideration in this appeal. The first I plan to discuss is whether the complaint adequately alleged that defendant HHS is liable for the contract obligations of EngagePoint, Inc. as a mere continuation of EngagePoint. Under Maryland law, the mere continuation doctrine is one of four exceptions to the general rule that a corporation that acquires the assets of a predecessor corporation is not liable for the debts and liabilities of the predecessor corporation. The mere continuation exception has not been codified in Maryland, and the Maryland Court of Appeals has not established an exhaustive test. In Academy of IRM v. LVI Environmental Services, the Maryland Court of Appeals mentioned a five-factor test from Rhode Island, but found that it could decide that case without adopting the test. The court in that case found it did not need to reach the question of adopting the five-factor test because there was first, adequate consideration paid, and second, there was no allegation that the two management employees that had gone from the predecessor to the successor were instrumental in the transfer of assets. Neither of those conditions is present in this case. First, with respect to adequate consideration. In Academy of IRM, the plaintiff did not contest the adequacy of the consideration, and there was substantial evidence that it was sufficient. First of all, the price of the security interest had just been negotiated 3 months before the transfer of assets. And secondly, a bankruptcy court had overseen and approved the sale of a majority of the debt. In this case, the adequacy of consideration is contested. The complaint alleges that the sale of assets from the predecessor EngagePoint to the successor HHS was part of a sham auction designed to avoid paying the obligations to plaintiffs. HHS did not even exist at the time of the supposed auction when it supposedly purchased the assets. The auction was conducted in a manner that would prevent a competitive bid because it was conducted 9 days after it was announced, and it was not announced to interested parties. In the 9 days, the complaint alleges would be insufficient for a third party to do an adequate evaluation of the assets and make a competitive bid. And last, unlike in the IRM case, the value of EngagePoint's assets had not been recently determined by an arm's length negotiation at the time of the sale of the assets to HHS. The second condition the Court of Appeals considered in the IRM case, that there was no allegation that the management officials that transferred from the predecessor to the successor were instrumental, is also not the case here. In this case, the CEO, Mr. White, was instrumental in both the loan transactions and the sale of EngagePoint to HHS, and he was the CEO both of the predecessor and successor. Therefore, it's our contention. So, the conditions that prevented the court from reaching whether the five-factor test are not present in this case. And it's our contention that the Maryland Court of Appeals would adopt the five factors it mentioned in the Academy of IRM case, which was summarized and later applied by the Maryland Court of Special Appeals in 2016. Applying these five factors, the complaint plausibly alleges that HHS is a mere continuation of EngagePoint. The first factor is whether there was any change in ownership and management. Here, plaintiffs allege that there was common management and control between the two entities through White, who was the CEO of both the predecessor and successor, and 3 other members of the management team that transferred from EngagePoint, the predecessor, to the successor, HHS.
Mr. Jarrett?
Yes.
This is Judge Clay, and you may be getting to this next, and if you are, I apologize. I understand the argument with respect to the, for lack of a better term, continuity between management, but what about the ownership interests between the two entities?
Yeah, that's exactly where I'm going. Well, first of all, no court has held that common ownership is required for there to be, no Maryland court, has held that there's required to be common ownership between the predecessor and successor for there to be a mere continuation. In the Baltimore luggage case, it explicitly states
that common stockholders are not essential, and that's at 562 A second, 1286, 1293. And that's and in that they're citing to the restatement. And so our contention is that the common ownership is not necessary, but that this case is unique in that Brevet, the venture capital firm that exercised de facto control, acted as a de facto owner of Engage Point prior to the sale of HHS, and that Brevet controls and owns HHS. The second factor is the continued existence. The second factor under the five-factor Rhode Island test is the continued existence of the selling corporation. While the district court was correct to note that the complaint alleged that Engage Point continued to exist, additional allegations made clear that Engage Point had conveyed its valuable revenue-generating assets to HHS. Additionally, the complaint alleges that Engage Point's management team left Engage Point and went to HHS. And the record in this case shows that Engage Point has failed to appear to defend the case. Taking these allegations as true and drawing reasonable inferences in favor of plaintiff, the complaint adequately alleges that Engage Point no longer exists as a viable entity. And the Hearn v. Telesis International case states that the continued dormant existence of a predecessor corporation does not preclude successor liability. The third factor, yes.
Where did you plausibly plead that HHS is Engage Point's corporate successor? Can you point to that?
We did not use that term. We said that we used the mere continuation term.
Well, if that's so, is that enough? In other words, the question is, did the district court erroneously dismiss the claims against HHS? All you pleaded or pled was Engage Point's enterprise, not that Engage Point is a continuation of HHS. So, why was the district court right?
So we did allege that HHS was a mere continuation of Engage Point, and that it was and alleged that it was liable, therefore, for Engage Point's contractual obligations to plaintiffs. So I think we did allege that it should be liable under successor liability theory, and additionally we alleged facts along with them assuming the business and management team and assets of Engage Point that HHS had done so. So I believe that we did allege successor liability under those terms. The third factor that applies under the Rhode Island test is adequacy of consideration. And here I want to point out two things. One is that we do allege that there was a sham auction that was designed to insulate the liabilities, and it was designed that the assets were reformulated into HHS to avoid the liabilities to plaintiffs and others. And then the facts that I mentioned earlier that discussed about why there couldn't have been a competitive bid. The district court incorrectly, in our opinion. Yes.
I'm sorry, it's Judge Clay again. The appellee raises the issue that the auction was held in compliance with state law, in this case, New York. Should that have any bearing on this court's review here?
I don't think it does. I think that you have to look at the facts of whether there's sufficient facts to allege that or to conclude that the complaint plausibly alleges that there was insufficient consideration, and I think that there is. And I want to turn to one point of clarification is the district court had focused on the loans that the venture capital firm Brevet provided to Engage Point in determining that Engage Point received adequate consideration. But I think that's incorrect. I think the inquiry of whether there was adequate consideration under the mere continuation analysis must focus on the sale of assets to the purported successor and not the earlier transaction in which the lender acquired the security interest. And so it's not that the value when the venture capital firm obtained the security interest, it's the value at the time of the sale, and whether that was sufficient. The fourth factor under the Rhode Island test is the transfer of any instrumental employees from predecessor to successor. Again, the CEO, White, left and transferred along with 3 other members of the management team. And then the fifth factor is the purpose of the asset sale, which, again, we allege, and we think plausibly allege, that it was a sham designed to put the assets beyond the reach of and to avoid the liabilities to plaintiff, Engage Point's liabilities to plaintiff. The second issue that I wanted to discuss that's before the court's attention is whether CEO White was plaintiff's employer within the meaning of the Maryland Wage Payment Collection Law. There's a question here as to which test to apply, whether it be the economic reality test that Maryland Court of Special Appeals applied prior to this court's decision in the Salinas v. Commercial Interiors case. For the reasons that we set forth in our brief, we think that the Maryland Court of Appeals would apply the updated Salinas test.
Well, let me ask you this. Isn't the job of the Maryland court to interpret Maryland law, and that we really don't have any business doing that?
Yes, Your Honor. However, when they haven't spoken on the issue, I believe that the case law says that the Fourth Circuit is supposed to to analyze what they think the Maryland Court of Appeals would do.
Well, what do you think about the Campusano case that the Court of Special Appeals handed down?
So I think that the allegations here establish that White, that the CEO, was a employer under that test as well. I think the Salinas test is it goes through and sort of explains what had gone wrong with the economic reality test, and I think that the Maryland courts would find that persuasive, especially given the Campusano.
So the Salinas test was applying federal law, wasn't it?
No, the Campusano case, the court concluded that the Maryland Wage Payment Collection Law was sufficiently similar to
the Salinas test. That's Judge Wynn's case. He was trying to figure out. We were trying to figure out federal law.
That's correct. The Campusano case.
And here we got to try to figure out what state law is, I guess.
Right, and the Campusano case.
But anyway, but you think the results are the same either way, don't you?
Yes, I do. And the Campusano case.
But it makes a difference. You just got to say you win any way you look at it.
That's what I hope for. The Campusano case imported the economic reality test that was being used in the federal context at that time. That's why we think that the Maryland Court of Appeals would import the updated economic reality test from the Fourth Circuit. I think for the reasons that we explained in our brief, it's our contention that the facts here meet either test, and we went through the various elements. I think that what's most important from the Campusano test is that what the Court of Special Appeals was looking at was the role of the putative employer in causing the corporation to undercompensate employees and prefer the payment of other obligations or the retention of profits. And I think keeping that in mind, the 4-factor Campusano test indicates that Mr. White was the employer, as he had the power to hire and fire, and was responsible and perpetrated what we allege is the unlawful action, as he acted as CEO while Engage Point decided which debts to pay and enacted the scheme to have plaintiffs agree to accept payment of their wages under the severance agreement in biweekly payments, and then they reformulated Engage Point as HHS without paying the owed wages. Last, the third issue that we wanted to raise was that we think the court abused its discretion in failing to grant plaintiffs one opportunity to amend the complaint. the law is well settled.
Did you make a motion to amend?
We did not make a motion to amend. After we received the motion to dismiss, we contended that our allegations were sufficient with respect to these counts.
So you didn't ask for leave to amend, right?
What we did ask for in our opposition to the motion to dismiss was we asked that the court deny dismissal, or in the alternative, deny dismissal with prejudice, and that's
how can the court err on denying you leave to amend when you didn't ask for it? That's what I'm getting at.
That's correct.
You can't come up here and claim error when you didn't ask the court to take the action that you're complaining about.
So the error would be, we think the court erred in dismissing the case with prejudice without giving the plaintiff one opportunity to amend.
You're saying it should have been dismissed without prejudice?
That's our argument in the alternative, is that if the court thought that that the allegations were insufficient, which we disagreed with, it should not have been dismissed with prejudice, which we did request, and that's in the conclusion of our opposition at Joint Appendix page 80. If you don't have any further questions, I'll reserve the remainder of my time.
Thank you, Mr. Jarrett.
Thank you.
Mr. Jaffe?
May it please the court, I'm Peter Jaffe, representing defendants appellees HHS Tech Group and Bradley White. And we respectfully submit that the district court was right to dismiss all claims against HHS Tech and against Bradley White. And we further believe that the district court didn't abuse its discretion in dismissing the claims with prejudice. So as with HHS, I think we want to be clear. We have a situation where we have a senior secured lender who has been operating at arm's length to a debtor and who foreclosed on those assets after the debtor couldn't pay its debt. The lender created a company to receive and operate those assets. Now, as a matter of Maryland law, we believe that the newly formed company is simply not a successor to the debtor. And to hold otherwise, we submit would invert the law of secured creditors. It would mean that secured creditors, after they foreclosed on assets, would become liable to unsecured creditors. As to Bradley White, what we have here is a CEO of a direly distressed company that finally collapsed. And so this is not some kind of closely held corporation where he was also the owner of the company. This is not Bradley White, LLC. Ultimately, Bradley White was just another employee himself. And as a matter of Maryland's payment and collection law, he is therefore not an employer who's personally liable for wages of employees who didn't get their final paychecks.
Mr. Jaffe? Yes. This is Judge Klee, and I know we're going to talk some more about Camposano versus Salinas test, and I also know that the Maryland Code doesn't give us much direction. Is there any other case you can point us to that more affirmatively states that an executive like Mr. White in this case does not qualify or satisfy the definition of employer under the Maryland Wage Payment Collection Act?
Yeah, I think that this is fairly stated in Camposano, which in 3 different places talks about the fact that you've got a non-owner general manager of a company, not a general manager, supervising employee of a company who's not liable. I also think that we need to flip that question. There is not a single case that anybody has cited where an individual was held liable as an employer in the absence of a closely held corporation where my favorite example is Matt's Kebabs. That's a case in the district court below, where you've got somebody who owns a company, runs a company, and for all intents and purposes is the company. Those are the only cases where we found any court, whether in Maryland or the district courts below, finding that an individual could be personally liable, tantamount to an employer. And finally, we believe that the district court was affirmatively right to dismiss these claims with prejudice, and therefore it was not an abuse of discretion. And first of all, I just want to make clear, there are a number of claims below that were abandoned right out of the gate. Those have not been appealed, so those are out of the case. But even for the 2 claims that are left, this successor claim against HHS and this employer claim against Bradley White. We believe that the court was right to dismiss with prejudice because the plaintiff didn't just fail to allege enough facts to state a claim. We believe that they affirmatively pled themselves out of court by alleging that there was, a valid foreclosure sale, and by alleging that Bradley White was, a CEO, not an owner. So if I can elaborate on the successor liability point, what we think here is that they have not pled successor liability. They've affirmatively pled the opposite. And if you look at the Maryland cases, we think they're pretty clear. Successor liability and mere continuation, it's about protecting creditors against owners who are shuffling assets around companies to avoid paying the creditors. And that's why the cases emphasize that common ownership is critical to the inquiry. And I believe that all of the cases say that, from Baltimore Luggage to Academy of IRM to Nesson and others. As the Maryland courts rightly put it, and as this court noted a few minutes ago, you need continuity of entity, not just continuity of enterprise. Now here, the executives haven't alleged that the putative predecessor and the putative successor are owned by the same people. And very surprisingly, to our mind, they haven't alleged who owns EngagePoint at all. They certainly haven't alleged that Purvey owned EngagePoint. And that's telling, Your Honor, because they do allege that they were executives of EngagePoint, one of them for 10 years. In fact, one of them alleges that he had some stock in the company. So if anything, the only owner he's ever pointed to is himself. And that's telling. If anybody could allege who owned these companies, they could have. And by any account, ownership is a critical question to the inquiry. And they simply never alleged it. To the contrary, what I think is clear is that they are alleging that Purvey is not an owner. I think that the counsel just conceded that a few minutes ago. What they describe is an arm's length relationship with a secured lender, not some kind of ownership interest that Purvey had in the company. And so I think that they absolutely failed the threshold. They've alleged a situation that falls into the Academy of IRM case. Let me put it a slightly different way. Here what they've alleged is that a secured creditor validly foreclosed on the assets and that they are unsecured creditors. So applying the black letter law of secured lending, that means that Purvey had priority to EngagePoint's assets, not the executives who weren't secured at all. It's not like they had any kind of lien. They hadn't obtained a judgment. They hadn't tried to obtain a judgment lien. The assets were rightfully Purvey's after EngagePoint couldn't pay its debts, which were substantial debts. The plaintiffs allege about $65 million of debt. And so we submit that the affirmative allegations that they've made requires dismissal of this case and requires it with prejudice. We don't think that they can state a claim in those circumstances. And moving on to Bradley White's supposed employer liability, we submit that, first of all, there's no question who actually employed the executives. It was EngagePoint. Now, the executives contend that Bradley White owes unpaid wages of employees because he was the CEO when EngagePoint finally collapsed. And so by virtue of that position, he's somehow their employer. We just don't think that states the Maryland law under any of the tests that have been posited here. And so we don't think that this court has to decide Maryland law. We think that under any test that's been positive, Bradley White is affirmatively not the employer. So I do think I want to reiterate the point that I made a few minutes ago. Some of these cases where employer means something more than employer are joint employment cases. So that's where you've got two corporate employers who share employment responsibilities. The paradigmatic example is you've got a general contractor and a subcontractor, or a prime contractor and a subcontractor. And that's what this court was facing in the Salinas case. I also do want to emphasize the Salinas case was about the Federal Labor Standards Act, and it expressly said that it was not making any judgments on the Maryland the Maryland wage and payment and collection law. There's a footnote where it says, we're not commenting on that. That claim is moot here. But in that case, you've got a prime contractor that's requiring the subcontractor and its employees to say where the prime contractor's clothing and their logo and is directing them on work sites and actually distributing paychecks and whatnot. I just don't think that the joint employer type cases are what's going on here. And then, the second sort of case where you've seen courts finding that sometimes employer means more than employer is where you've got these closely held corporations. So, you've got Matt's Kebab. That's one of the cases that we cited below, where Matt is the owner, Matt's the manager, Matt runs everything. The business even bears his name. That's an example of the type of case where you might hold an individual liable. But here, we don't have that sort of relationship. Bradley White didn't hire these employees. You can see from the employment contracts that they attached to their opposition to the motion to dismiss. You'll see that somebody else hired them, the prior CEO. You'll see that they had a whole assortment of sort of executive benefits that comes from having an executive employment contract. These were one of them was previously the chief operating officer and later the senior vice president of corporate services. The other one was the executive vice president of professional services. So it's hard to imagine that Bradley White, who's a non-owner, who is not, he's a CEO, but he's only been in the position for a couple of months. He's come back to the company, which is in dire straits. And he does ultimately convey to these employees that they've been terminated. It's hard to imagine that CEO exercises so much overwhelming control over this company that he should be liable as an employer. If anything, you've got one of the plaintiffs, Jagian, alleging that he actually does own some of the company, and that he's again the senior vice president for corporate services. If he's alleging that Bradley White is liable to him for unpaid wages, presumably he's liable to a bunch of employees himself who are under his control. And I just don't think that the Maryland law requires that. The Maryland law, like I said, has never held somebody liable outside of a very substantial ownership interest in a company like this. And as a result, we just don't think that under either Camposano or Salinas that you have a situation where Bradley White can be deemed the employer here. And then finally, to address the dismissal with prejudice, we think the district court was right. Again, we think that the plaintiff has affirmatively pled themselves out of court by alleging a foreclosure sale of valid antecedent debts. And again, I think the plaintiff just conceded a few minutes ago that the antecedent debts were perfectly valid. Hasn't alleged anything further on that. That runs straight into the rule of Academy of IRM and a whole bunch of similar decisions in other states, by the way, that Academy of IRM cites that hold that a secured lender who forecloses simply is a successor. And we think that the plaintiffs also pled themselves out of court by alleging that Bradley White is the CEO who came in the last couple of months, and that he was really nothing more. In any event, we don't believe that the district court would have abused its discretion after looking at these things and looking at the position of these plaintiffs who truly had a great amount of inside knowledge about this company, EngagePoint, certainly knew the critical elements of the claims. They didn't amend their complaint as of right when they had the chance. That's 21 days after we filed a motion to dismiss. In fact, even in our motion to dismiss, where we point out certain key errors as to there's an issue that's not before this court, but there's an error as to one of the parties that's no longer in the case. They even said, we're not going to amend our complaint. We'll fix things during discovery. In light of that, I think the district court is well within its discretion to say that they, first, as you noted earlier, they hadn't even asked to amend. All they asked is that the complaint not be dismissed with prejudice. They certainly never proposed what amendments they would make. Usually in these sorts of cases, you see the plaintiff file a proposed amended complaint where they show what kind of changes they would make to cure the difficulties. I think I may have heard a beep there. So if I may just quickly finish.
There's no beep.
Yes, you may. I think you did hear a beep, and you may sum up the sentences, right?
You have 7 minutes left. There was no beep on my end.
Oh, there was no beep.
There was no beep, but I'm coming to the end anyway. And so for those reasons, Your Honors, we believe that the district court was right to dismiss the claims of successor liability against HHS. We believe the district court was right to dismiss the claims of employer liability against Bradley White. And we believe that the district court was right to do so with prejudice.
Very good. Thank you, Mr. Jakey.
Thank you.
Jarrett, you've reserved some rebuttal time.
Thank you. Just 2 quick points. I think that just want to reiterate that as with respect to mere continuation and successor liability, that ownership is not required, and that the Academy of IRM didn't just say, well, there's not continuation of ownership, so this is over, and neither did Nissen, a prior case that was in the products liability arena as opposed to contract. And in fact, it's the first case, the Baltimore Luggage Company v. Holtzman case, explicitly states that common stockholders is not essential to a finding of mere continuation. And then with respect to the second issue with the CEO, I think the Campusano case is certainly distinguishable. In that case, the individual who was the putative employer didn't even have the power to hire and fire. That's not the case with the CEO. And these requirements that Mr. Jaffe mentioned, as far as there being the company being closely held, or that the individual act as the owner, the supervisor, the manager, those just aren't present in any of the tests. And I think that if you run through the tests, whether it be the Salinas or the Campusano tests, that White, in his position with his authority, qualifies as an employer under the Maryland Wage Payment Collection Law, which the definition of employee obviously is not very helpful in the statute itself, but it is clear that it should be defined expansively, and that is clear. So if you don't have any other questions, that's all I have.
Thank you very much, Mr. Jarrett. We appreciate the arguments of counsel, and your case will 1491 will be submitted. Madam Clerk, we can adjourn for the day.
Yes, sir. After I adjourn, I'll end this conference call and be calling the judges back.
Thank you.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.
Conference recording has stopped.
Thank you, everyone.
Thank you.
We're sorry. Your conference is ending now. Please hang up.